And we're here hearing argument in our first case, number 21-4064, United States versus Combs. Mr. Macbeth.
Thank you, and good morning, Your Honors. My name is Colin Macbeth. I represent the appellant, Thomas Combs. In this case, Your Honors, there was a breakdown in the adversarial process. District courts are supposed to act as neutral, detached arbiters who decide disputes based on a factual record developed by the parties. But here, the district court took its own evidence outside Mr. Combs' presence and without giving him advance notice, and it acted as a de facto victim advocate on behalf of his ex-wife. On these highly unusual and troubling facts, a remand for resentencing is required.
Mr. Macbeth, can I ask you, it seems to me there were two breakdowns in the adversarial process. So assume for the sake of argument, I agree with you that this was a violation of the Federal Rules of Criminal Procedure. There was also a violation of the claim presentation rules that say when you think a district court judge has made a mistake, it's your job to point out that you think a district court judge has made a mistake. Could you, and I guess I'll just confess to you, at least my inclination is that you're probably right on the error question, but I'm troubled about whether you're right on the clear or obvious error question. So could you, I guess, talk me through that? Not just why was it wrong to do this, but why was it clearly and obviously wrong to do this?
Sure, Your Honor. So there are a couple things I can point to demonstrate the plainness of the error. So start first just with the plain text of the rule. The rule says that at a revocation hearing, a releasee is entitled to various rights. The rule does not, on its face, by its language, distinguish between the so-called guilt phase and sentencing phase of a revocation hearing. It says these are the rights you get at a hearing. The commentary also makes clear that a revocation hearing encompasses both guilt and sentencing. It says that the court shall hold a revocation hearing at which it shall determine guilt and sentence. We also have the 2005 amendment to the rule, which added 32.1b2e, which gave releasees the right to allocute at a revocation hearing. And allocution, I think everyone agrees, is undeniably a sentencing right. So if the rights in Rule 32.1b2 include sentencing rights, and the text of the rule does not distinguish between the two stages, it's logical that the rights apply at both stages. And then, in addition, we have the fact that Rule 32.1 was meant to codify the protections from Morrissey. And if you look at Morrissey, it uses the phrase revocation hearing and revocation decision, and it's clear. It says that revocation hearing encompasses two distinct questions. First is the factual question, did the parolee commit a violation? And the second is, if he did, should the parole board revoke parole and send the prisoner back to prison? And then, crucially, it also says that the need for procedures guaranteeing accuracy extends to both of those phases. It's not important just to have accurate fact-finding at the first stage, but also at the second stage.
So what do you say to the government's argument, again, positing that you're right, but the question is still whether you're clearly, obviously right, that it is a little bit odd, maybe, to say that the evidentiary rules at a revocation hearing are more strict than they are at an initial criminal sentencing? That one of the government's arguments is that seems a little odd. Could you address that?
Sure. So 2 points. The first is, even if that's true, which for the reasons I'll say in a second, I don't think it is, the rule says what it says. The plain text of the rule says these are the rights you get at a revocation hearing, and it does not say only certain rights at certain parts. So if the court is going to apply the plain text of the rule, that's the result. But if the court wants to sort of, give that a coherence or a logic, I think, part of the reason is that in the real world, as a practical matter, at supervised release revocation proceedings, often the guilt is not really in doubt. At least in my experience, it seems like many releasees stipulate, as Mr. Combs did in his case.
They test positive for drugs. They're arrested for some other offense.
Right. Or, the probation officer says he didn't show up to the meeting. There's just really nothing to talk about at the guilt phase. That's not true in every case. I'm not saying every case, but in my experience, in most cases. The real action is at the second stage where the question is, okay, so what do we do now that we have found a violation? Does this actually warrant sending you back to prison, or are there steps we can take short of that that would not result in re-imprisonment? And so it's really important at that step that we have these procedures to guarantee accuracy. And Morrissey talks about the reason we have to have these protections is that liberty is at stake. That is why there is a due process right, because liberty is at stake. And again, liberty really is decided at that second part. Obviously.
But just to confirm, you haven't pursued forfeited or not, a freestanding due process claim. The only claim you're making is based on the rule.
That's correct, Your Honor. And I mean, my understanding from this court's cases is that due process and Rule 32.1 are essentially coextensive. I don't think there's much, if any, daylight between the two. So I think we are only making a rule-based argument, but it really is the same thing as a due process-based argument. So in addition to that, as to why we have more protection at the sentencing stage, I think a revocation hearing is very different from a trial in the sense that, if you're convicted of a crime, even if you don't go to prison, that can be a devastating event in your life. You lose your right to vote, to serve on juries, to receive certain federal benefits, et cetera. In the revocation context, the finding of a violation by itself is really just not that important. I mean, from the releasee's point of view, what matters is not, did the court find that I didn't show up for a drug test, but am I going to go to prison because of that? That's what really matters. And so I think, again, to the extent the court wants to explain why the rule would provide these protections at both stages, that's the reason, is that this is different from a trial or a plea because the consequences are different for the person involved.
Counsel, let's say, if you get, we agree with you or we assume that you've established error and that it was plain, the third prong under the plain error review, I'd like to talk about that a little bit. It looks like from the transcript, there's, if we're talking about the call and any reference to the call to the chambers, it's maybe 4 lines, maybe 7 lines in a 35-page transcript where the district court talks on and on about the multiple violations. You're familiar with it, the various things beyond that call. How is that, 2 or 3 lines, 4 to 7 lines prejudicial or not harmless in the context of everything else that is discussed by the district court?
Sure. So a couple of points around it. First is the overall transcript is about 35 pages, but the part of the transcript where the court is explaining its sentence is only about 4 pages. That's JA 251 to 254, and during those 4 pages, the court is actually engaged in a colloquy with Mr. Combs. So if you take out the parts where Mr. Combs is speaking, it's really more like 2.5 to 3 pages. So the court is not saying a whole lot. It does mention the call. It doesn't mention the March 2020 letter or anything else about specifics of why the court thinks Mr. Combs is violent. It refers to this call. And it also talks about how the court needs to protect the public and Mr. Combs' mental health issues. But crucially, in the district court's mind, the mental health and substance abuse issues are linked to the violence. The court says at several places, the reason that you're committing these acts of violence is that you have these mental health issues. And so it's not, I don't think you can so neatly disaggregate, the fact that the court is focusing on mental health from violence and the threats. I mean, the court says, for instance, on JA 252, he says, but your mental health issues have endangered people. In other words, the reason I care about your mental health issues in this context is that they're making you do and say violent things. Or then on JA 253, the court says, I have a job to protect the public, not only in terms of various acts today, but also in terms of danger to the public, threat to the public, and it's all been predicated upon whether you are or are not handling your mental issues. So it's true that the call itself is only about 4 lines, but it's infused into the rest of the district court's explanation.
Could you help me understand? I'm trying to articulate precisely what is the question we're asking under substantial rights. I mean, it requires us to ask some counterfactual question, but could you how would you articulate what the counterfactual question we're supposed to be asking is at the prejudice stage?
Thank you, Your Honor, and this is important because it can be tricky in this case. So the factual question or counterfactual question is, assume that the evidence should not have come in. Assume the evidence should have been excluded, and that at an alternative sentencing, that evidence was not before the court.
I thought you might say that, and I mean, that's possible, but I'm sure you've thought about this. I mean, another possible counterfactual question is, assuming the district court had properly disclosed this information, what is the likely outcome, right? Like, what? I mean, those seem like equally in some ways, equally plausible counterfactual questions? Because after all, under even under your interpretation of the rule, at least under your interpretation of the notice part of the rule, he didn't have any right to not have the evidence considered. He had a right to know that the evidence was going to be considered. So why? Now, I understand your argument on the hearsay point, maybe that's different, but at least on the notice argument, why isn't the counterfactual question, had he been notified, would the result have been different?
So I think the reason is the same reason that in the hearsay context, the court doesn't ask, well, how would the cross-examination have gone if you'd had a chance to cross-examine? And the answer is it's just impossible to know after the fact how someone who's never seen this evidence, including to this day, and Mr. Clemens has still not heard any details about these calls, it's impossible to know or to show how he would have responded to that. And the Sixth Circuit made this point in the Hayes case. The government in that case argued, well, Mr. Hayes should have to show how he would have responded to these victim impact letters if he had been told about them ahead of time. And the Sixth Circuit said, well, there's no way he can do that.
Was Hayes a case involving a forfeited error or preserved error?
It was a forfeited
Okay, because I mean, I think everything you're saying makes total sense to me in the context of a preserved error, right? But when I heard you just say what you're saying, and there's a lot of sense to it, but it sounds like a structural error argument, like this is the sort of error that's just impossible to know how it would, right? Which makes total sense to me in the context of harmless error analysis. But I get the sense the Supreme Court has said that when we're dealing with forfeited errors, we really don't do structural error analysis. I mean, Cotton says that. I mean, these cases, right? My sense is that the Supreme Court has repeatedly told the lower courts we don't do structural error analysis for forfeited errors.
That's true, Your Honor, and I'm not arguing it's structural.
But when you say it's impossible to know, so we have to presume it was bad, that to me sounds like structural error.
I'm not saying there's a presumption. I'm just saying the standard can't be that we have to come in and point to evidence that we have still never seen and said, here's how we would have responded to it. I mean, if that is the standard, then it will be literally impossible to show prejudice in a case like this. I understand plain error is a hard standard to satisfy, but it's not supposed to be impossible. There's supposed to be a way to show it. And in fact, in the I believe it was the Hamilton case, which is unpublished, but this court's case, the court found plain error, found all four prongs satisfied and reversed, even though it was forfeited and the defendant couldn't show exactly how he would have cross-examined or fought the evidence if he'd had the chance.
So in addition to turning back to the merits of the substantive rights thing, I mean, there were a lot of reasons to revoke this gentleman's supervised release. I mean, I think the district court goes through them, right? That this had been a long continuing course, and I could easily see the district court imposing exactly, given all of the reasons to do it. I think it's pretty clear that the district court would have had plenty of reasons to do the exact same thing if the phone call had never happened. So how should we analyze that, what seems to me fairly obvious fact that this is not a case, I mean, I agree, the district court mentions the call and that's troubling and seems like a problem, but it's also pretty clear the district court may well have reached the exact same result even without the call.
So perhaps it would have. I obviously can't tell you for certain that it wouldn't have, but the question is not, is this 37-month sentence substantively reasonable? In other words, is it supported by all the properly admitted evidence? The question is, would this particular court, in this particular case, actually have imposed the same sentence if the evidence had not been there? And I think, we have reasons to believe the court attached a lot of significance to these calls. Not only the fact that the court mentioned them at the hearing, but also when the court got the call, it took the really rather extraordinary step of contacting the U.S. Marshal Service on behalf of Ms. Dancy, finding out whether there was a detainer, and then presumably reporting back to her and telling her, don't worry, the man I'm about to sentence can't harm you. I mean, that's a really, really unusual thing for the court to do. At least I think it is. I don't think the court would have done that unless it found the calls quite troubling. Again, like I mentioned in the brief, the reasonable probability standard is, at least, that prong is actually not super demanding. It's a lower standard than more likely than not. So not even a 50% chance. You just have to show it undermines confidence in the outcome. And I think when a court is, again, taking these steps outside the courtroom on behalf of a victim based on a call like this, we can at least have some doubt, not be confident that the sentence would have been the same, especially, again, because this was a 37-month sentence. The previous two sentences were 0 months and 2 months. And to be sure, there were new aggravating facts here, but we don't have to show that the entire sentence, the entire increase in the sentence was based on this call. We just have to show that 1 month or even just 1 day of the sentence was the result of the fact that the court considered these calls. And I think, given, again, the fact that the court mentioned the call twice, gave a short explanation of its sentence, and took these extraordinary steps, I think that's at least, there's a reasonable probability that that would have been the case. And as for the plain, to go back to your question about the plain error, it is true that this court has never explicitly raised and rejected the argument that Rule 32.1 does not apply at the sentencing phase. But all the court's cases that I'm aware of assume that that's the case, and I think the reason they assume that that's the case is that the rule just doesn't give any indication that it doesn't apply at sentencing.
I see you're running out of time on your initial argument. I guess if we're going to go back to plainness, one question is, what would you have us say about Ruby? So that's one.
Sure. So Ruby, to be candid, is an outlier, and it's one case. This court's cases have taken the opposite route, again, without being explicit. They have done that. Ruby also mentions the Third Circuit's opinion in Lloyd, which is much like this court's opinion in Ferguson. It reverses and remands for new sentencing because the error was not harmless. Now, again, Lloyd did not explicitly reject the alternative interpretation, but it's consistent with our view. The government cites the First Circuit's case in Colon-Maldonado, and if you look at that case, there's a footnote saying that in the previous case, United States v. Doust, the First Circuit said that Rule 32.1 applies at both stages. And then, in Colon-Maldonado, the court adds a footnote saying, well, arguably that was dicta. So fair enough, I'm not saying it's binding, but the point is that's the logical interpretation that pretty much everyone except the Tenth Circuit seems to be coming to. And again, the plain language of the rule says it applies at both steps. So unless the court has any more questions, I will stop for now and save my time for rebuttal.
Okay. Thank you.
Good morning, Your Honors. This
Good morning.
is U.S. Attorney Matt Phelps on behalf of the United States. I just want to jump in and say I disagree that Ruby's an outlier. Ruby is the only appellate decision that addressed whether 32B2C applies to sentencing. It's the only opinion. I don't think it's an outlier. I think it's, in fact, the only opinion on point. I do want to also make one...
But what do you say about your friend on the other side's argument that there are all kinds of decisions that just seem to assume that that's obviously wrong?
Your Honor, I don't think that that's the case. For example, if you look at the decisions, they tend to be centered on subsection B2E related to allocution, which does apply to sentencing. And if you look at Morrissey, and you look at, for example, where B2C shows up in Morrissey, and you look where B2E shows up in Morrissey, one looks like a trial right, and one looks like a sentencing right. If you look at Morrissey, when the Supreme Court laid out its due process protections, it did it in the course of a hypothetical parole violation. It did it sequentially. It started at the beginning and it went to the end. And it divided it into two stages. The first stage was an arrest and preliminary hearing, and the second stage was the revocation hearing. The confrontation rights in B2C, the public interest balancing that needs to be done, under Morrissey, that occurred at the preliminary hearing. Now, we obviously don't necessarily have that analog, but one thing is clear is that when the Supreme Court identified the rule that then became B2C, it was not talking about sentencing.
But we're not construing more. I mean, and maybe the Rules Committee screwed up, or maybe the Rules Committee could have done something different, right? I mean, based on Morrissey. To the extent this rule is just intended to codify Morrissey, fair enough. But, I mean, we have to interpret the rule, not Morrissey. And I guess, just to candidly, there's some intuitive force to the government's argument about how this system should sensibly work, but I guess one of my bigger hesitations is that is a bizarre way to codify that. If the government's view that this same rule at some points refers to part of the hearing but not other parts of the hearing, and then we're jumping around, and this part applies at the first part, this part applies at the second part, this part applies throughout, that is not the way that it strikes me that a hypothetical drafter who was drawing the distinction that the government wants to draw would have ever drafted Rule 32.1.
So my observation, Your Honor, is that 32.1b is actually written in chronological order. If you take away subsection B2D, which is the right to counsel, because that's not in Morrissey, all the other rights are in Morrissey, A through C and E. And if you look at the way those rules were pronounced in Morrissey, again, it was done under this hypothetical parole violation, and it starts at the beginning and it goes to the end.
So wait, does the government think the right to counsel is a violation and sentencing right, or just a violation right? Or when do I, in the government's view, when do I have a right to counsel at a revocation hearing?
Sure, you're right. So that's why I said in the hypothetical, take out D, because D's not in Morrissey.
But I'm construing a rule that has D.
That is fair, Your Honor. But if you D would obviously apply at every stage of the proceeding, Your Honor. But generally,
That's a relief.
A talks about notice of, right? That's kind of what happens first. A trial happens second. That's what B2B and B2C are about. And then sentencing happens last. And the last rule, the last subsection in the rule has the right to allocution. So that's the way I read that, Your Honor. And again, to your point about it being odd that confrontation rights, public interest balancing would happen at a revocation sentencing when you don't even do that at a regular criminal sentencing. The 10th Circuit in Ruby found that a persuasive factor in deciding that B2C does not apply to sentencings. All of the existing sentencing law related to criminal prosecutions existed at the time of Morrissey. And there's nothing about Morrissey that said, we're going to change sentencing law as it relates to violations of supervised release. In fact, Morrissey says this is not intended to have the formality and rules of a full-blown criminal prosecution. And so the 10th Circuit found it persuasive that if the understanding of sentencing law existed at the time of Morrissey, and Morrissey didn't intend to change any sentencing law, then Rule 32.1 didn't intend to change sentencing.
But I mean, maybe the argument, putting aside the argument that the text of the rule just says what the text of the rule is, two other arguments on the other side that you're familiar with obviously are, one, at the guilt phase and sentencing phase, there's a break of usually months between the finding of guilt or the acceptance of the guilty plea and the imposition of the sentence, whereas your colleague on the other side says these revocation things are, we don't have like a, should I revoke your supervised release, then we'll have a PSR and come back in 5 weeks and decide how long, right? That's not what happens in this setting. So that's one difference. And sure, maybe this would say that you get somewhat more rights at revocation, but in another sense, you get a heck of a lot less, right? Because after I'm convicted, there's a PSR, and I get the PSR, and I have an option to object to the PSR. I have all kinds of procedural rights at criminal sentencing that even if the government is wrong here, I don't have at my revocation hearing. So why doesn't that address the apparent anomaly question?
So I agree with the construct, Your Honor, that there are far less rights throughout a violation of supervised release.
And even if I get this one, there are still far less rights.
Correct. But again, I just don't see any intention in Morrissey or anything based on the text of the rule that was intended to make violation of supervised release sentencings more formal, more structured, have more due process protections than a traditional criminal sentencing. I do want to make one factual point that I regret not emphasizing more in the brief, and that is Judge Bennett says at the beginning of the revocation hearing, for the record, Miss Dancy called my chambers concerned to see if there was a detainer concerned about her safety. There is no law that says any disclosure of evidence must occur a day before, 2 days before, 10 days before. He says it at the beginning of the sentence, and he says it for the purpose of making a record. There's been some sense that who knows what occurred during this phone call, but the judge intended to make a record. There's no reason to believe that the judge intended to make a record at the beginning of sentencing, but then just decided to omit some horrifying details that the victim disclosed.
Well, but that can't be. I agree with you. The rule, this is a problem with the rule. The rule doesn't say when the disclosure has to happen, but if I think about what the purpose of disclosure rules is to give people an opportunity to consider and react and possibly present counter. It strikes me as quite a aggressive swing to say that assuming there's a disclosure obligation, you can meet it by saying, all right, let's get into it. Before we do, by the way, here's some bombshell evidence that you were never told about before the start of this hearing. That strikes me as a really, again, I understand you have the argument that B doesn't apply, but assuming that B applies, that strikes me as a very aggressive argument.
So,
Well, but one thing you might say is that counsel could have at that moment said, well, could we have an extension and could we resume the sentencing in 2 days so that I have an opportunity to consider and explore that evidence? And nobody did. That goes to the question of we are here on plain error and not any.
and again, Your Honor, and to talk about so a little bit of substantial rights and the cumulative nature of the evidence, this was not a bombshell. Miss Dancy had been victimized for years. Her fear was known to everyone for years on the record. This was not a bombshell that was disclosed. I suspect if it was a bombshell, counsel would have piped up and said, we need some more time to evaluate this.
Well, do we even know what she's, I understand you said the district court said for the record, I got a phone call. Do we even know what she told the district court judge?
I can just take the judge for his word that he intended to make a record of what she did.
He may have intended to make a record, but I mean this sincerely. I've read this transcript. Based on that transcript, I do not know what she told the district court judge.
Beyond what the district court said.
She called me and she was concerned, but that could mean a lot. I think we can agree that could mean a lot of different things.
Well, Your Honor, let's take a look at the March letter, for example, that she sent. Was it going to be any worse than that when she expresses, concern that
It could have been.
fear for her life?
It could have been. It could. I mean, again, I don't know that. I mean, I'm not saying I know this, but I mean, she could have said he called me and is threatening to kill me. I mean, based on what the district court said, I genuinely don't know what she told the district court.
That's, yes, Your Honor, but understand that, for example, the underlying violation that he pled to arose out of Mr. Combs sending a text message to his now ex-wife with a picture of him holding a Glock saying, don't think I won't use this. Ms. Dancy's fear was well known to everybody, and Your Honor, I'll refer to a passage in Christman, which is a case that's cited by the appellant in this case. And again, this touches on the cumulative nature of the evidence, but it says, Christman is quoting a prior opinion in Patrick, where the evidence upon which the sentencing court relies without previously notifying the defendant is of the same character, allows the same inferences, and most importantly, is subject to the same arguments in rebuttal as evidence in the record of which the defendant is already aware, it seems logical to conclude that advance notice would not give the defendant any additional incentive or ability to challenge the evidence. Right? It's about the defendant's ability to respond to the allegations. The defendant's counsel prepared a sentencing memorandum and addressed the relationship with Ms. Dancy. I mean, if he had known about the phone call, what is the sentencing memorandum from the defense counsel going to say that's any different? He says, look,
We don't. I mean, point's well taken. There's a bunch of information that's known, but it's probably hard to make that argument without knowing what it is. It seems to me there's a response to that. I mean, I can't tell you what I would have put this different until I know what it is in the first place. It seems to me the question is, looking at this record, is it likely that, or reasonably probable that, the result would be any different? And, your colleague talks about, looking at this hearing and kind of compresses the amount of discussion. As I read the hearing, a lot of it is about the history and the cumulative effect that you're talking about. So I think it's fair to look at the whole history along with exactly what he talks about in the last several pages. What's your response on that issue?
I agree, Your Honor. This judge in particular always gives a very detailed procedural history at the start of every hearing, and a lot of the troubling facts and the troubling history by the defendant are baked in at the very beginning of the hearing. And in fact, when I was given an opportunity to speak at sentencing, I said, much of what I would say you already covered in your extensive procedural history. The judge covered the defendant's mental health, he covered his criminal history, he covered the underlying conviction. He even went so far as to say that he read the underlying psychiatric evaluation of the defendant related to the underlying state charges. And as to the sentence in particular, it's a bottom of the guideline sentence. And in every case that's been cited by the appellant, it was not a bottom of the guideline sentence. In Hayes, it was a top of the guideline sentence. And in fact, I believe the appellant said, well, it wasn't so much about the top of the guideline sentence, it was about that it was a significant sentence. The court in Hayes actually says, because this was a top of the guideline sentence, we find that this defendant's substantial rights were affected. In Ferguson, it was 9 months above the sentencing guidelines.
Should one other thing, as I was looking at this, the previous revocation hearings and the previous revocation sentences where the district court does seem, and this maybe cuts both ways, district court does seem to have a particular interest in what the witness who called says. I mean, he says, like to hear from her, he volunteers that before. So on the one hand, that makes me think, well, they have something here. He seems to have a maybe more, oversized interest in this particular thing. But the flip side of that is even in the earlier proceedings where he expresses that interest, and when there's letters, his revocation sentences are pretty light. I mean, extends it by a month or two. So, yeah, if you could just comment, it seems to me that cuts a little bit both ways, but on balance, even with that, he's not giving the most severe sentences in the revocation context.
So one thing is clear, Your Honor, is that the revocation sentences grow each time.
Right.
The second one is greater than the first, and the third one is greater than the second. And I believe the district court frequently makes comments about the court's patience running thin. And I've paid close attention to this. And so, although the prior sentences were much lighter, as you indicated, the judge appeared to be very invested in this case, very invested in the victim, very invested in the history. And so I think it's relatively normal that the sentence would grow at each stage and even still, to your point about the sentences being relatively light, this was a bottom of the guideline sentence.
But the flip side, I guess, or a related thing to that, isn't it, that the court also, as part of this, I agree, seemingly unusual level of interest in hearing from one particular victim, seems to, in explaining the decision to go easy on him, some of the earlier times says, you've got this person in your life, this person's a positive influence in your life, and I'm gonna, do that. Basically, this is a really aggressive interpretation, but one interpretation is like, as long as you're with her and as long as she's good with you, I'm inclined to be charitable. And the moment your relationship with her is completely broken down, I'm throwing the book at you. I know you're going to say it's the bottom of the gun, but compared to what the district court had done to him previously, this is sort of throwing the book at him.
So I would just add that the district court made frequent comment about the defendant's mental health and his mental health issues. And I don't think that his mental health is confined to his relationship with his ex-wife. Certainly, the defendant argued at sentencing, well, now that this relationship is over, you don't have to worry about this anymore. But the defendant had significant mental health issues, substance abuse issues. There was no indication that they abated while he was not in prison. And so I certainly see that a lot of this stemmed from the relationship with Ms. Nancy, but at the same time, he even admitted himself he did not have his mental health issues under control. He said that at the third revocation hearing, and the judge said, I appreciate your candor. I think the sentence is increased. It was the third, again, as the district court said, not one, not two, but three. You made the point that I would make that it wasn't necessarily the book, it was the bottom of the guideline sentence.
Can I ask you, regardless of whether this is or is not permitted by the rule in the government's view, do you have the ability to make any sort of representation? Is it common to not notify defendants at revocation hearings before the hearing of things the court is going to be considering in revoking the sentence? As a descriptive matter, is this common or uncommon?
I am not aware of any established practice in our district of any memorandum that's issued prior to a revocation sentencing that would say, these are the following issues for the court. This is the evidence for the court that the court intends to rely upon. No, I'm not aware of any kind of standard for that. I mean, again, in a traditional sentencing, you have the PSR and Rule 32, and that creates that framework. And again, Your Honor, I will just conclude with that the appellant in this case is seeking to impose a level of formality and structure and process on a revocation sentencing. Revocations are supposed to be less formal than criminal prosecution. Sentencings are supposed to be less formal than trials. And we are really kind of turning that established standard on its head, where, for example, a district court is now going to have to perform a public interest balancing and confrontation analysis every time a victim sends an impact statement to the court, even where that victim impact statement is disclosed. Thank you, Your Honor.
Thank you. I think you have a little time left for rebuttal.
Thank you, Your Honor. I'd like to just start by addressing this question of the cumulativeness of the phone calls. If you look at Ms. Dancy's letter, at the end of the letter, she says, quote, "There is so much more I can tell you and show you if you need proof." So even in March 2020, Ms. Dancy has not given the court all the information that exists at that time. And then between then and the revocation hearing in February of 2021, we have 11 months that pass. So a lot can happen in 11 months. And the government just asked the court to assume that the new details from the letter and the 11 months, that nothing new happened. And the Sixth Circuit in Hayes rejected that argument. The government made the same argument. You should just assume it's cumulative. And the Sixth Circuit.
But that's fair, I guess. But you're in effect asking us to assume there's some incredible amount of information beyond already bad information, and I mean, I guess in the situation where we don't know what it's heard, each side can say whatever. But I mean, there's a bunch of severe information, spanning multiple years. I guess your argument is true, but in an unknown, in a context where it's unknown, we should assume the worst.
I don't think the court has to assume the worst, but I think the way this court can tell what a district court attached importance to is by looking at what the district court said. And at the sentencing, the court mentioned the calls twice. It did not mention the March 2020 letter. It did not mention the assault or the Ocean City incident. None of that came up.
Well, it may be not. It depends on how you look at the hearing. And I kind of went to my question you earlier and to your colleague. I don't know that it's completely fair to just say reciting the procedural history is kind of formalistic procedural history. It seems like the history here is part of the information that the district court's considering, the cumulative effect of everything. So when he does that and then turns to the sentencing, it's a little bit myopic just to stop, just to focus there and not look at the other aspects of the hearing. I mean, is there, you give any credence to that?
No, I take your point, Your Honor, but I guess the point I'm making is, yes, the court did recite the procedural history, including the fact that there had been previous revocations, but it did not specifically say anything about, the Ocean City incident or the March 2020 letter or anything like that. Yes, it was all in the background, certainly, and we can assume the court was aware of it, but it didn't mention it specifically the way it did these phone calls. I'd also.
Well, but isn't it fair to say the phone calls might be more vivid, if you will, and more different than other evidence that the district court ordinarily considers? And so even if they didn't make, I think you just have a very hard argument that things would have been different without this.
Also,
And we are here on plain error, right? There was no objection. I just looked, and you weren't the lawyer at the time. I bet there would have been an objection.
I wish there had been an objection, but there wasn't. So yes, we're here on plain error. Again, I think, a couple points. One is, again, whatever Ms. Dancy told the court, it prompted the court to do something really rather extraordinary, which is to reach out to the Marshal Service on her behalf and relay information back to her. That is, I hope at least that is extremely unusual. And I don't think the court can just assume that that indicates that this didn't make a difference to the court. If I could, I'd like to just make one quick point about the plainness of the error, and that is that 32.1b2c, which contains the right to cross-examination, also gives the releasee the right, quote, to appear and to present evidence. So if the government is right that subsection B2C does not apply at sentencing phase, then that would mean that the releasee has no right to appear at the sentencing phase or to present evidence at the sentencing phase. And that just cannot be right. That cannot be what the drafters of the rule intended. That makes no sense whatsoever. And I think I'm over my time. So unless
You are
there
over your
more
time.
questions, I will leave it.
Thank you very much. We appreciated both of your arguments. We're sorry we can't come down and shake hands, but you started off the day very well. We appreciate your arguments.
Thank you.
You can start right in. As soon as you all get settled, we're happy to hear from you.
And please put your microphone covers on.
Good morning.
Good morning.
May it please the court, I'm Eric Plackey for Appellant Montgomery. In this case, the district court clearly erred when it found, and I'm quoting from pages 62 to 63 of the joint appendix, that there was an attempted breaking and entering for the purpose of committing a new felony, that being to terrorize. That's the specific finding, that intent to terrorize, that's really at issue here. This is not a case where there are, as this court said in Stevenson, two permissible views of evidence. Rather, this is a case where there's simply no evidence of intent to terrorize.
Whether or not there's intent is a factual question, right?
It is.
So we review a decision that there was intent for clear error.
For clear error, yes. Yes.
Okay.
And that's what Stevenson addresses, is that standard of review for clear error. And Stevenson said, if there's two permissible views, then you can't have clear error. But here, there's not two permissible views, because there's...
How is having a loaded gun, kicking the front door, kicking the back door, coming on property without written consent when you're not supposed to otherwise, not at least, how does that not go in some way to the finding the district court made?
It certainly goes to the intent to enter unlawfully, the kicking, and the fact that he wasn't supposed to be there without the consent, although he had been, according to EM, the estranged girlfriend, he had been there earlier. You'll recall that the 911 call,
Right.
she tells the operator he has returned or come back.
And
Yes.
you consider that positive, returning back with a gun?
It's not positive.
Okay.
It's certainly not good behavior.
Okay.
But the fact that he has a gun is obviously...
A loaded gun, by the way.
A loaded gun. It's a revolver, so there are rounds in the cylinder. But what we don't know, and this is partly related to the absence of evidence, is how EM even knew he had a gun.
Well,
It would be one thing.
What difference does it make whether she knew
She
or
may
not?
not have known.
Excuse me?
What difference does that make? The statute focuses on his intent,
Right.
not what the recognition of what he's doing is.
Well, that goes to what I'm about to say about what he was doing with the gun. We
Okay.
don't know because there's simply no evidence presented of whether the gun was pointed or brandished or at least displayed or just tucked in a waistband.
well, can I ask you about that? Because, your brief says that she may not have even known, but as I read both the factual basis of the plea and the PSR, they both say, quote, EM called 911 to report that an armed man was attempting to break into her house. I don't know how a person who doesn't perceive someone as being armed would report him as an armed man. So even assuming that I mean, I'm inclined to agree with Judge Motz that it doesn't really matter if she knows, but even assuming that it does, doesn't the factual basis of the police stipulate that she represented that she was aware that he was armed?
She did say, yes.
Then why does it matter how she knows? As long as she knows he's armed, why does it matter on what basis she knows that?
Because that is indicative of both his intent, whether he's brandishing, pointing the gun, that kind of thing, or whether, again, it was simply a gun he had with him. But it also goes to the degree of fear that she experienced. North Carolina.
Okay, I just want to be sure I understand this argument. So you're saying that someone that would just be holding the gun just gently by his side, that he would not be guilty of terrorizing anybody. You have to wave it around, point it at somebody. Is that right? Is that your argument?
It depends upon the entirety of the circumstances. What the person does with the gun is certainly part of it. But again, on these facts, on this record.
Well, in this record, my colleague has just pointed out to you, he's trying to get into one door, he's trying to get breaking into one door, breaking into the other, with the loaded gun in his hand.
Well, actually, the only time that the record establishes that the gun is in his hand is when he places it between the back door and apparently a screen door.
Right.
Whether it was in his hand before that, there's
Well, it had to get from his hand to there, right?
unless it was in his pocket, in his waistband, in a coat. Again, absent.
Well, at some point, he had to take it from the pocket, the waistband, or whatever, to put it in his hand and put it down. I mean,
Yes, he did.
it didn't fly. Or if he threw it down, that might be terrorizing. But anyway, go ahead.
Right, but at that point, he's trying to hide the gun. He's not using it to threaten anybody or seek to terrorize.
Well, but maybe there's an innocent explanation for that, but maybe there's not. And is there an argument, I suppose, that the fact that when he had reason to believe law enforcement was showing up, he felt the need to not terribly effectively hide the gun? I mean, again, if we're talking about a clear standard of review and a permissible view of the evidence, it strikes me that one permissible view of that behavior is that he knew he was up to something no good before then and was basically having I need to hide the evidence of the bad thing that I was just doing, which in some ways provides some modicum of evidence of what his intent was before the police showed up.
Certainly, he was engaged in an attempted misdemeanor breaking and entering, even without any intent beyond just the act.
And sure, that's one interpretation, but another interpretation was, as a person, I know how this looks. I just showed up at my estranged partner's house, brandishing a gun, trying to kick down the door. I probably shouldn't be holding a gun when the police arrive because that's going to look really, really bad given what it was that I was doing right before they arrived.
Well, it could be that
that.
it looks bad because of what I was doing. It could also be because it looks bad because I'm not supposed to be here to begin with. Or it could be it looks bad because
Aren't you making the point? I mean, you just offered three alternatives. I think the first one was, the one that might be the worst for your client. And I mean, under our standard review, if any of those three are reasonable, aren't we required to affirm?
If a permissible view of the evidence establishes the intent to terrorize, all those others are short of that intent. Are short of that intent.
So you say it's not permissible for an interpretation of the facts to be, all right, I've been doing enough bad stuff here, including with the gun, my desire to hide it is to overcome the fact that I've been terrorizing, or I had the intent to terrorize when I was breaking and entering. You don't think that's a even permissible view here?
We would contend not, Your Honor. The court has already pointed to both the factual basis. The same language is essentially repeated in the pre-sentence report, which the court accepted. Interestingly, the government relies on the Domestic Violence Protective Order, which is at Joint Appendix 168 to 170, which was appended to its sentencing position paper. That's a consent order that has no findings and no conclusions about any prior behavior by this man or any potential risk or anything like that. So that doesn't really get them anywhere. And then the two officers that testified both recount the 911 call where EM says that the man has returned, again implying that he'd been there earlier that day, and certainly under certain circumstances, when he had her consent, he could be there to visit.
But there's no evidence in the record he had her consent to be there to visit. I know there was a statement by counsel at the hearing that he had been there earlier to visit his kids, but when I looked at the record, I don't see any evidence that he had previously been there by consent.
Right, there's no evidence one way or the other.
Sure. But then why isn't one permissible view of the evidence is he was here before, I was scared, but I guess I didn't call the police then because he left, but now he has returned, and now I'm really scared because not only was he here and left, but now he's back. Why isn't that a permissible inference?
For several reasons. There's no evidence about what went on before.
I know, but if I call the police saying someone has returned, it strikes me that at minimum a permissible and probably the most natural inference is, that's a weird way to refer. He's returned. That implies that there's some connection between what happened before and what's happening now, that I'm describing it. I just wouldn't describe, my spouse coming home today after work as saying she's returned, just like she returned. I mean, it strikes me that there's something about the use of the word return that, again, at least to me, strikes me as permissibly connoting that what's happening now is in some ways a continuation of what was happening before.
A continuation, yes, but not an establishment of intent to terrorize. We were talking about the police officers. The only other things the police officers really added when they testified at sentencing was the second officer, Officer Carlton, confirmed that EM said when he asked her that the dents in the front door were not new, and he confirmed that she wasn't interested in pressing charges, even for a misdemeanor breaking and entering. Again, there's simply no evidence of him doing anything with the gun, which relates to how she knew he had one. And there's no evidence that he said anything that was threatening. The North Carolina courts require a high degree of fear, a state of intense fright or apprehension. In the Griffin case cited in the briefs, the court describes a violent attack. In the Walker case that's cited in Griffin and is also in the briefs, the court talks about the victim being violently beaten and about people, one or more people at least, making a comment to the effect of, "Get her." There's nothing like that here. Nothing like that here.
But that strikes me as why your client isn't also guilty of aggravated assault or some other crime. It strikes me that it can't possibly, I agree, the facts of most of the cases I've been able to locate involve more extreme conduct directed at the victim. But it strikes me that it can't be the case that the reason the victim wasn't assaulted is because the police showed up to prevent the assault from happening, right? It can't be that to violate a statute that is focused, as Judge Mott said, on the defendant's intent, it is a defense that the police stopped you from escalating the confrontation.
No, it's never going to be a defense to.
Well, so I guess but that means that it cannot be required that the defendant actually go through with a violent assault on the victim, because that implies that, that you could never, no matter how much you terrorize someone, if the police show up before you lay a hand on them, you can't be guilty.
Well, the violence there was one of the circumstances from which the court found the intent to terrorize. All I'm arguing is there is nothing like that here. The final point, if I may, the brief cite this unpublished decision from this court in Tabram, which is actually from the same district court, same U.S. Attorney's Office, same Defender's Office. And it's the same in that the underlying offense is a 922G offense. It's the same that there was a 911 call, but there's some differences. There, the defendant pulled his car into the yard across the walkway to the front door, according to the court, only steps from the front door. There, according to the 911 caller, he went back to his car to get a gun. And importantly, there, the district court listened to the recording of the 911 call and concluded that the caller was, quote, quite scared. No recording offered here by the government. Thank you.
Thank you. Edmondson?
May it please the court, Mr. Plackey, Veronica Edmiston for the government. As the district court rightly described, the events of August 6, 2020 were a terrifying situation. And that's on page 76 of the joint appendix. The court's findings were not erroneous and the legal analysis was sound. And for the reasons in our brief, we would ask that this court affirm the district court's decision.
But before you get into that, could I just ask you a question? It's not preserved, but it was bothering me, and I just wanted to get the government's take. I'm not sure this cross-reference is as obviously correct as everyone seems to think it is, because, you know, the Bowden decision of this court addressed whether, well, 54A, breaking and entering with intent to commit a felony, is generic burglary. But the language the government relies on here wasn't added until almost 20 years later. And I mean, so I guess, could you just address, it doesn't seem to me self-evidently the case that our Bowden decision actually indicates that this was a correct crime. It's not been argued, it's 1,000% forfeited, but could you just address that briefly for me?
Yes, Your Honor, thank you. The Bowden case stemmed from the Taylor case, the United States v. Taylor case from the Supreme Court, where the Supreme Court, in applying the definition of burglary for 924E, found that it was an unlawful entry into a building with the intent to commit a crime. And we would contend that that's exactly what happened here.
But is terrorizing a separate freestanding crime under North Carolina law? Because before it was intent to commit a crime, which the Supreme Court in Taylor said that, I mean, that's classic common law burglary, but intent to terrorize someone is not obviously classic common law burglary.
Not when
Unless terrorizing someone is itself a crime under state law, but I don't understand that to be a separate violation of North Carolina law.
Is it? I had that question too.
the acts that would underpin any act of terrorizing would be a crime.
Well, is there a statute you can tell us, you can refer us to that says terrorizing is a crime?
No, Your Honor. There is a terrorism statute, but it's not applicable under these facts. But the acts that would be required in order to terrorize someone would be a crime. And that would be the United States position on that.
So standing up.
Standing alone? In other words, is there North Carolina, are there cases in which somebody has been convicted of terrorizing?
No, Your Honor.
Okay.
There are cases where obviously folks have been convicted of communicating threats. That's where someone says, I'm going to harm you in some way, and the other person has a reasonable belief to believe that's going to occur. That would be an act of terrorism under this statute. And that would be terrorizing or could be terrorizing. Or an assault. That could also be terrorizing. But any facts that would underline the actual terrorizing of another person, the government would contend that would be a crime. It's just not going to be called terrorize. The court found that it was hard to imagine why he had a loaded gun, especially because there had been some contention he was there to visit his children. That was corroborated by the evidence on page 54 of the joint appendix when the officer saw him place the gun between the doors and the other officer found the loaded .38. The court found that she's calling 911. She clearly doesn't want him there. Officer Salava saw that the male had returned and was actively kicking or attempting to get into the house. The caller acknowledged that he had tried to kick in the front door, then went to the back door and was kicking, as one officer described, with the foot of his shoe. It wasn't the toe portion of his shoe, it was the bottom of his shoe. And as far as the gun being in his hand, of course it wasn't brandished as far as we know, but it was readily accessible because as soon as police showed up, he was able to quickly hide it between those two doors. So it was readily accessible to him. But again, as this court stated earlier, it is not what she knew or whether she was in fact terrorized, is what his intent was as he was bringing
Counsel, what if there was no gun? What if the evidence was that, he's back, he's kicking, he's, gone to the back door, now he's kicking there, everything, he's 911, all that sort of stuff. Is having the gun essential to the intent to terrorize?
No, sir, it's not.
Would you think that evidence would support the conclusion without, the presence of a loaded gun?
Yes, sir, I would. Because we have someone who has been ordered not to commit any further acts of violence, which indicates there has been a prior act of violence between these two folks. He has come back, which again does not, it's almost a neutral fact. It's not necessarily a good fact or a bad fact, but the fact that he has come back now with a loaded gun, has tried to kick in the front door, has now gone to the back door and is trying to kick it in. Even without the gun, those are acts of violence. Trying to break into someone's home where he's not allowed to be in a violent manner. As he's trying to, again, kick in the door it's not opening an already opened window. It's not anything like that. It's actually trying to break into someone's home. And that by itself would be violent. If this court has no further questions, the government would stand on its.
Thank you very much. Appreciate your argument. Sir, do you have any rebuttal?
Yes, Your Honor, thank you. Again, the government goes back to the domestic violence protection order and says, well, that must indicate prior violence. But it's a consent order, and on pages 168 through 170, and this is a standard fill-in-the-blank form, there are no blanks filled in. The only finding the court makes is that the parties were present and by whom they were represented.
But your friend on the other side points out it says further acts of violence, and normally if I say you shall not commit any further blank, it subsumes the idea that I have committed at least one previous blank.
On page 170 of the joint appendix, it says, it is ordered that the defendant shall not assault, threaten, abuse, follow, harass by telephone, visiting the home or workplace or other means, or interfere with the plaintiff. Doesn't say further acts. That's an important point. This is a consent order with no finding, no determination of any acts of violence between them. That cannot support the inference the government seeks to draw there when there's no findings. And when it doesn't say additional acts, it just says shall not.
So your position is just at a thin air, two parties agreed to not commit violence to each other without there ever being any concern about that to begin with?
Well, these orders allow for agreements about being or for orders rather, about being apart, about not calling, about not visiting, harassing. It goes way beyond.
Sure.
The relief sought goes way beyond actual protection from physical violence. And again, in the absence of findings of violence, it's that absence of evidence that's the problem here. The government didn't offer the 911 tape for the court to assess it, as happened in Tabor. The police officer's testimony was very brief, didn't really add anything. The government didn't call EM to talk about what had happened earlier that day, what the returning was actually related to. The government didn't call EM to say, well, I knew he had a gun for X, Y, or Z reasons. Again, leaving us completely in the dark as to whether this gun was being brandished or was tucked into his waistband, perhaps even the back waistband. Again, we're in the dark. No evidence from EM or from anybody else, and again, it's the government's burden about anything being said. It's that lack of evidence, Granted, this standard is only preponderance of the evidence. And granted that clear error is an uphill battle for someone in my shoes to undertake, especially as third counsel in the case. However, it's that absence of evidence that gets us back to the initial point that under Stevenson, there have to be equally permissible views of the evidence, and we don't have that here.
Thank you very much.
Thank you.
Appreciate your argument. We will go directly to our third case. Is that all right? We're ready whenever you are, Mr. Martinez.
Thank you, Your Honor. Michael Martinez on behalf of the appellants. May it please the court. Appellants Natural Land Trust, Upstate Forever, and South Carolina Trout Unlimited initiated this citizen suit to stop and to obtain a remedy for Arabella Farms' repeated violations of the Clean Water Act's prohibition on illegal and unpermitted discharges of pollutants into our nation's waters. Arabella Farms' disregard of the act caused the dumping of literal tons of sediment into a critical tributary of the East River, a popular trout fishing destination in upstate South Carolina. This sediment choked off this valuable water resource and eliminated the clear, cold, well-oxygenated water that trout and its food supply depend on, and that serves as an indicator for water quality and a healthy aquatic ecosystem. Arabella Farms' violations of the act damaged my client's property, organizational, and recreational interest, and they sought to exercise their right to citizen enforcement under the act, which is authorized to ensure that the public has a mechanism to restrain illegal and unpermitted discharges into our waterways. Citizen suits may be precluded in only two limited circumstances, neither of which apply here. The district court fundamentally misapplied the administrative enforcement diligent prosecution provision to bar my client's suit, and we respectfully request reversal of the court's decision. I'd like to begin first with the district court's error in rejecting the plain language of the diligent prosecution provision in construing the scope of that provision. The district court held that the provision bars not only claims for civil penalties, but also claims for injunctive relief, despite the clear text of the statute dictating that it applies only to civil penalty actions. The court relied entirely on the First Circuit's decision in Situate which, as we pointed out in a supplemental authority letter on Friday, was just overruled in a unanimous en banc decision by the First Circuit.
So, counsel, that's on that issue. There's, I think I understand the textual argument there. I think it has some persuasive effect. There's fairly compelling policy, I would say, reasons against that, but the text is the text. Here's my question. Let's assume I agree with you that an injunction action in a citizen suit is not excluded from a textual standpoint. Doesn't to pursue an injunction, even a permanent injunction, you still have to establish the 4 factors of injunction that include not just a violation, but a balancing of interest and all those factors. Does Gwaltney, while not precluding an injunction from a jurisdictional standpoint, effectively mean you could not get an injunction? I mean, how could you get an injunction given what Gwaltney says, about how you could have a agency enforcement action, go through all these steps, people rely on it, and then the citizen group, which has a right to bring the suit, how could you satisfy the elements of an injunction given Gwaltney, even if it's not jurisdictionally precluded?
Well, I think in Gwaltney, the court held that the Clean Water Act citizen suit is limited to claims for ongoing violations of the Act.
Agree. I don't think Gwaltney extends the text. I'm not trying to say use Gwaltney to say, that the text includes injunctions. But in reaching that conclusion, and maybe you just say, well, that's dicta, so you don't consider it. But in reaching that conclusion, there's so much reasoning that would cut against an argument from an injunction. If you assume, which you'd have to at least at this point, I know you're not conceding it, that there's been a commencement, that it's diligent, that these regimes are comparable. In those circumstances, how could you ever get an injunction?
Well, I think injunctive relief is especially well matched with the requirement for an ongoing violation, and the combination of Gwaltney's requirement of an ongoing violation and the diligent prosecution bar restricting it to claims for injunctive relief, I think the risk that courts have said exists with allowing citizen suits to proceed when there's agency enforcement is the risk of impeding agencies' ability to negotiate with the polluters, with the defendants. And an injunctive relief doesn't really have that same risk because the court is not going to be able to order duplicative punishment with respect to injunctive relief.
Well, it maybe not, you say it wouldn't undermine that, but if the agency, and particularly here, DHEC, which has been designated as an appropriate agent based on the South Carolina regime, goes through its enforcement actions, reaches an agreement, requires, whatever it requires, and, it could be substantial requirements. And then the citizens group comes in and says, no, I don't think that's enough. The citizen has already done all that sort of stuff. I mean, isn't that undermining those negotiating efforts? And again, that's a different question of whether you are barred jurisdictionally from bringing the injunction. I'm kind of going a step further and saying I agree with you, maybe that textually you have a point there, but I just don't see how an injunction could be established. You could still say there's a violation. Maybe you say there's an ongoing violation. I just don't see how you ever meet the other elements of an injunction.
I think the existence of an ongoing violation, which is required, presumes that there is some ongoing damage, ongoing discharge of pollutant into a applicable waterway.
Sure.
And seeking injunctive relief would, of course, require us to prove some irreparable harm that would occur. And I think that a district court would be capable of managing that request for injunctive relief from a citizen suit while recognizing the agency enforcement that may have been ongoing. But the requirement of an ongoing violation will still have to be met, and the allowing injunctive relief to proceed is appropriate so that citizens have the mechanism to stop ongoing violations.
Can I ask you a question about the naming issue?
Yes, Your Honor.
So on the one hand, it feels very persnickety to say that if you, and I'm going to ask your friend on the other side about this, and one level their claim seems very, very persnickety. On the other hand, there's the sort of whole jurisdiction, small, not really jurisdiction, but rules like this should be clear. What's your best response to how frigging hard would it have been to just say the same organization in both your notice and the complaint? I mean, and that rules should be simple and straightforward and mechanical, and how hard would it really be to list the exact same entity on both forms?
I suppose it wouldn't be extraordinarily difficult, but I think it creates an extraordinarily technical application of that requirement. And,
Oh, I agree. It is extraordinarily technical.
and it really places form over substance when the contents of the letter communicated that there were two upstate South Carolina chapters of the national organization Trout Unlimited, that their mission intends to promote and protect cold water fisheries like the East.
Oh, no, I know. And in lots of arguments, like in this case, there's no realistic danger that they didn't understand who they were hearing from, all of that. But the argument for bright line rules is that if you don't have bright line rules, there will be cases in which it's really hard to apply in all other things being equal. And that one way to get around that is just to say, I mean, it's really not that hard to comply with the bright line rule. So maybe I understand that in this case, it seems very technical because it strikes me as implausible that they can mount a plausible argument that they didn't understand who it was they were getting notice from. But once we go down that road, I can imagine cases where it is hard to figure out. And one way to just head that off at the pass is just say, it should just be the same thing. Why shouldn't we say that?
Because it creates somewhat of an onerous obligation.
Copy and paste is onerous?
Well, it creates a situation where potential plaintiffs need to, and you may have various organizations, various entities that want to pursue enforcement in a suit, and you end up in a situation where you have to specifically identify their corporate or entity structure in order to qualify for such a rule. And I don't think that's what the notice requirements in the provision or the regulation requires. And Your Honor, I'll next move to the issue of commencement. The diligent prosecution provision contains several requirements intended to guarantee the public's notice and participation in the administrative enforcement process that must be that must be satisfied before a citizen suit may be precluded.
Why should we, I've read your briefs on that, and I understand you advocate for the approach that the Milwaukee, I guess, case does, which says, the commencement arises when there's some public notice. That case even says that we're kind of merging that with the comparability analysis. It seems like, it's fine. I get the argument that you want public notice, and I get the argument in the comparable scheme standpoint, if there is or there isn't, that's a valid issue. It just seems to me like whether there's public notice has nothing to do with commence. That's just turning that word into something that it's not. Commence means when you begin, and there may be public notice, there may not be, and I mean, the notice of violation from DHEC says this is, this is the commencement, and it goes through a whole bunch of stuff. I just don't understand how we ever equate whether there is or is not public notice to whether something has commenced or not.
Respectfully, Your Honor, the problem with allowing a completely private document to trigger the preclusive effect of the diligent prosecution bar and bar citizen suits when they had no notice and no opportunity to participate in the administrative enforcement process thwarts the comparability requirement for comparable public notice and participation protection.
You're making my point. It goes to comparability. I mean, I understand that point, and I get the analysis that the way it works in South Carolina is different than in the Clean Water Act, and that may be enough to make it not comparable. May not be, but doesn't seem to me to have any bearing on whether you've commenced it or not.
In all of the cases, the Seventh Circuit case is the most explicit about defining commencement. But every other case, from Arkansas Wildlife Federation to Maccabee to Jones to Lockett, they all involve situations where the triggering commencement.
Yeah, but Arkansas really isn't that helpful. That was the case there, but they even contemplate that the notice of violation would have been sufficient. I think maybe I'm you know the cases I'm sure better than me, but I thought Arkansas, sure, and that the way it happened there did involve public, notice at the time of commencement. But even talking about that scheme, it certainly suggested it might be there through the earlier notice of violation stage.
And I'm not suggesting that only an administrative order can satisfy the requirement for commencement. But in that Arkansas Wildlife Federation, the Arkansas statute, even if it was a notice of alleged violation, involved the triggering of public notice and participation protection.
What's the harm of just using this issue where it naturally belongs in the comparability analysis?
I think that in this particular case, where the district court relied on the issuance of this private notice of alleged violation to satisfy the commencement to preclude our citizen suit, we have to look at whether that allowed for public notice and participation protections at that moment. And without that, and Your Honor, see, I'm out of time if I may.
Yeah, you can answer the question.
Without.
I guess your point is it hasn't really commenced for the world in general until they have notice of it.
It becomes problematic if you are able to preclude a citizen suit by entirely private enforcement that citizens and the public were unaware of and had no opportunity to participate in. And so that is the reason for tying the comparability prong to commencement. And it's important to understand that what is required by the Act is providing citizens significant public participation in the administrative enforcement process. Even all of the cases that apply the overall comparability standard emphasize the importance of significant public participation, citizen participation throughout the decision-making process and at significant stages of that process. And
I think you've gone well over your time now. You have some rebuttal time. Thank you.
May it please the court.
Good morning.
My name is Beth Partlow, and I represent the appellees in this case. And as the court has recognized, this is an effort on behalf of a neighboring property owner to overturn an enforcement or to get more relief than was afforded through the enforcement mechanism.
Can you talk just a tad louder?
Certainly.
Okay.
I believe some of the questions have gone to this question of civil penalty versus injunctive relief that's available under the preclusion of Section 1319G. And the court is correct that the language there says civil penalty. But in Gwaltney and in many of the other cases that have discussed the interplay between not only the federal government and the state government, but also between the federal and state governments and citizens, they have recognized the primary role of the states in enforcing the Clean Water Act. And where the state has taken action, it should not be undone by what a citizen suit comes in and tries to get.
So can I, because there's discussion in the briefs about something by the county and something by the state, and the briefing seems to consolidate them, and I want to see if we can separate them out. Are you relying in any way on the action by the county? No. Okay.
I think the court discussed that in some detail. It certainly was a significant history there.
But I'm glad you say that, because I mean, I'm looking at G6, and it says in which a state has commenced, and last I checked, a county is not a state. So it struck me as a fatal problem for any reliance on the county.
I think it is probably possible if the state had delegated that authority to a county. In South Carolina, that is not what happens. The counties do have a role. When you, particularly for something like a stormwater construction permit, the counties review that in the first instance. But enforcement.
Well, sure, but the federal law says an action by the state. It does not say an action by an entity designated by the state to do
Correct.
something.
And what we have here is the commencement of a state enforcement action. We have state involvement all over the summer of 2019. But we have the commencement of a state enforcement action in September of 2019 when they sent a notice.
Can I ask you, again, this may be sort of like a county is not a state. I have another question that may just reflect that I think this case may not be that hard. Why doesn't 44 CFR 22.13 just say that's wrong? That the EPA has defined what commenced means, and it does not include sending someone a private letter.
Your Honor, I have to tell you, I'm not familiar with what 22.
Sure, I will put, and I may have it wrong, which is why I want to give you an opportunity to address it, but I'm going to see if I can find the quote. It says, the EPA defines, quote, commencement of a proceeding as the filing of, quote, a complaint or, quote, the issuance of a consent agreement and final order. And that is 40 CFR 22.13. And then there's some references to it in 40 CFR 22.38. If that, and I understand you're getting it on the fly, and I don't want to, but I wanted to give you a chance to respond.
That's okay, and I would request the opportunity to do this a little bit more fulsomely when I've looked closely.
Of course, of course.
My recollection is that Part 22 is the procedural requirements when EPA is litigating a case. Because in fact, what happens in the administrative enforcement.
Well, and that may well be, but if it is just a general definition of what EPA considers commencement to mean, why wouldn't that bear on our interpretation of what commencement means in this statute?
Because I don't think EPA defines commencement for purposes of what a federal statute says. EPA commences its own action with a notice of violation when they do an administrative procedure. To get into a review of that, you have to actually have that consent agreement and final order that was referenced in that provision you just read me. So EPA begins its enforcement after it's gone through its administrative process. It either then elects to publish a consent agreement and final order, or if the parties haven't reached that, then EPA goes to court to seek civil penalties. When EPA is going to impose, when EPA finds somebody in violation, and this is not just Clean Water Act, it's all the statutes they administer, they send a notice of violation. That's also, whether it's publicly available, I don't know. It is certainly not something that is public noticed.
So can I ask you a question going a little further into G6? You know, we started with state law and then we said commenced. But now there's another word that we seem to be skipping over. So even if, you know, maybe I can think that the state, when they send this letter, commenced something, that they commenced an enforcement, that they, but obviously they didn't send the letter for the heck of it. They sent a letter to do something, and arguably that commenced something. But then when I read on in the statute, it doesn't say commenced enforcement, it doesn't say commenced inquiries, it says commenced an action, And it strikes me that the word action has a lot of, at least often, has a lot of connotations. And it to me, you know, I mean, the classic action is filing a lawsuit in court. I mean, when we say action at law or action in equity, but it's, you know, when we're having this question about whether things like notice are figured into it, I mean, I guess even if it commences something in the abstract, help me see how sending a private letter is in any normal use of the word action understood as commencing an action.
Action in that context is within 1319G, which is solely about administrative penalties.
Sure.
And so what that section, in our view, says is if the state, and there are provisions there that also bar where EPA has done this, commences an action under a state statute comparable to the, under a state law comparable to the federal. It also bars citizen suits when EPA commences an administrative action, as it bars citizen suits when the state has commenced an administrative action. And the federal commencement of an administrative action is, once again, that's very similar NOV. So I think all of 13G relates to the process that happens inside the agency as compared to a good bit of the rest of the Clean Water Act that talks about civil actions in court, even criminal actions in court. So in this case, the district court looked at the words that are there in the statute that say civil penalty and agreed with the reasoning of the First Circuit, which just disavowed its own reasoning last week. But there's also language from the Eighth Circuit that reaches the same conclusion. The First Circuit had found...
But aren't those, isn't the prior First Circuit opinion and the Eighth Circuit opinion largely policy-based reasons that, this really doesn't make sense? The whole purpose, like you said earlier, is, for the citizen enforcement to be there if the state isn't or can't do its job. That's what Baltney says. But, there's some appeal to that argument. I get it. There's another argument that, look, the administrative penalties are pretty steep under the Clean Water Act. Can be, I think, up to $25,000 or something a day. We're going to cut that off, but we're not going to cut the injunction off. So there's at least a plausible way you could distinguish those two. And then, but then you really kind of go to the text, and it's the only thing that's the text says is excluded is administrative penalties under D, which is fine, but there's a lot before D that talks about other things. I'm just having trouble getting past the text into policy and how you can make if you're looking at the text itself, how you can include injunction in that. Now, you heard my questions. I think there's some, on the back end, serious problems with an injunction given the other elements that might be satisfied. But how do you deal with the text?
Well, the way you deal with the text is the way the First Circuit long ago in the Eighth Circuit did, which is to say it ends up at an unreasonable result. And that's, part of that is the way the section is structured. If you look, there are actually three kinds of penalty actions that are barred, two of which refer to sections, one earlier in 1319, which is the EPA administrative penalties, which is a penalty-only section. And then one is to a reference in the Oil Pollution Act, which is also a penalty-only section. And then they throw in the citizen suit, where the penalties are all wrapped up in a single provision of the law. And I don't know that Congress considered, I could see a case where the state had imposed a penalty and had not secured compliance. So they say to an alleged polluter, you're going to pay $300 a day. And the citizen group comes in and says, well, wait a minute, you didn't make them stop.
But the citizens group might not even know about the action because you don't require there to be any disclosure of it? I mean, that's what I don't understand. I thought in response to earlier questions, you said it doesn't matter that there wasn't a notice of what the state agency did.
No, I don't believe I said if I did.
So everybody knew what they did.
Well, in this case, everybody did know, but in the scheme of things, the opportunities to participate, and this goes to the comparability, and there are two questions in that. One is whether you assess it as an overall comparability, which really just looks at penalties, plus whether the state is going after the same kind of relief that's afforded in a citizen suit, or do you do this rough comparability that some circuits have adopted, where you have to do each category of the 1319G procedure.
Okay, I'm sorry, we're missing each other. I'm talking about the commencement. I'm still back. You people have gone way beyond me. I'm still back at commencement. Now, is it your position that there was commencement by what the state did here?
Yes,
And did they make a public notice of that?
no, but they are not required to.
Okay, that's what I thought you had
There
said.
has to be an opportunity. If you use the rough comparability analysis, which we submit is the more stringent and certainly not required, it's what the court applied here. But if you use rough comparability, there has to be at some point public participation in the process. It does
It
not.
could be an appeal.
No, not necessarily. It can.
Not necessarily, but that could be it. Is that what you're saying?
Most of the cases that have considered that question have said no. There hasn't been anything in a Fourth Circuit case that has said that. There have been some cases that have found that after everything is already done, the opportunity for appeal is not enough. But that's not all that is here. Besides that, there's the opportunity for people to be on DHEC's mailing list for facilities. There's the opportunity for people to know what's being considered by the board. There's the opportunity to come in and participate in the board proceeding if you don't like something that's
And how do people know all that?
all public information.
So that there was public notice of what the state did here. Is that what you're telling me?
There is public availability of the information.
Well-
Well, and because we have to draw, did they put it in a newspaper? No. But I don't think they're required to put it in a newspaper. What they do make available is the board agenda, the board schedule, and every month, what's on that agenda is a list and a summary of every consent order that the agency has done. One of the things that makes the federal system different from the state system is that in the federal system, once it is signed in EPA, it is a final agency decision. In South Carolina, the final agency decision is rendered by the Board of Health and Environmental Control. So there is the opportunity for citizens to participate between the action at the staff level and the final decision.
But in this case, we haven't gotten to the order by the time the complaint is filed, right?
No.
That's correct. But I am not aware of any case that has said that the timing of the plaintiff's complaint vis-a-vis the public part of the process is important.
No, but we have said, I believe, that the timing for assessing whether an action has been commenced in a way to preclude the plaintiff's complaint is determined as, in other words, say that as of the time the plaintiff files their complaint, again, I know in this case we're debating whether an action was commenced, but assume there was no dispute that at the time the plaintiff files their complaint, no action has been commenced. And then assume that the day after the plaintiff files their complaint, something that is unambiguously a commencement of an action happens. Under our precedent, the plaintiff's suit is not precluded, right?
That is correct, because what is necessary to preclude the suit is that the state has commenced and is diligently prosecuting an action under state law comparable to this law. So
And that, in your view, does not require public notice of it.
it does not require public notice of the commencement. That is correct.
Your response is, am I correct that your response, that the public aspect of that is analyzed in the comparability portion of the analysis, assuming you do a rough approach?
Assuming you do rough comparability,
Yeah.
then you analyze public participation as one of the three aspects of rough comparability.
So if you were to say that, look, the public involvement under any regime is just woefully inadequate, that could still preclude or prevent the applicability of this bar to a citizen suit. It just does it at the comparability analysis rather than the commencement analysis.
Hypothetically, that is correct. You analyze whether a state action has commenced, and the cases are pretty clear that you look to the state's own procedures to see whether an action has commenced. And then are they diligently prosecuting? Because you get those cases that come up where the state starts something and then they never quite manage to achieve compliance. And then you say, and is it under a statute that is comparable to the federal procedure? And there again, comparability, if you were doing an overall comparability analysis, you just say, are the penalties similar, and is it designed to achieve the same result?
But we may not have addressed that in the Fourth Circuit specifically, but the cases arising out of Virginia certainly look at the public involvement, don't they? So does that imply that we are not doing overall comparability and suggest we're doing rough comparability, or at least you got to consider the public aspect.
Well, I think there are district courts all over the place on this issue. Certainly, the district court in this case said we're going to use rough comparability.
I'm talking about like the Piney, I think the Piney, I'm mixing my cases. Yeah. My recollection is that our circuit has emphasized the importance of the public involvement. At one point in Virginia, that was not there, and that was a reason we precluded the applicability of the citizen suit bar. So, I mean, whether we go with rough or overall, I mean, that seems like something the Fourth Circuit has already spoken is important.
Well, I think in Piney Run, the question was whether a member of the public or an affected person had any opportunity to participate at all. As I recall,
Right.
the statute at issue there didn't let anybody, I don't even think the agency had the authority to impose an administrative penalty without the consent of the alleged violator, if I'm remembering the facts of that case correctly. So,
It was way different than this. I don't
it's
agree.
hard to extrapolate a lot out of that. But in a case like this, where the state agency, in fact, did secure exactly the relief that these plaintiffs or the appellants were looking for, that's even more reason to have a bar here, whether that bar.
How do you say that? I mean, that may be the case. A lot of the notice of violation is about plans that are not yet, in place. So, I mean, I can certainly say, I can certainly see that the plaintiffs say, no, we've identified the same violations, but what you've required to cure them is inadequate. How do you say you've achieved the same relief that the citizens groups are seeking?
Well, in this case, what they are seeking is a cessation of the unpermitted discharge. The allegation is that for a period of time, there was grading activity and there was no coverage under a stormwater construction permit. The state administrative action secured the permit or imposed the permit requirement as one of its conditions. It actually went further than that. It required them to get a permit. It required them to assess the condition of the streams.
Yeah, but they also, in their complaint at least, they're asking for, remediation of the dam. They're asking for the remediation of any discharge of sediments that has happened. And maybe those will be part of the what comes from the consent order, but do we really know you've solved all I mean, I'm not saying that is necessarily the standard, but you kind of made the point that you've gotten the relief they want.
Exactly the relief they want.
I suspect they differ.
I suspect they do too.
Yeah.
But, if we have to argue about that later, we will. Certainly, at this point, what we have is a complaint that says you were releasing sediment without a permit. DHEC said get the permit and then go out there and assess whether there's a problem that's being created. And those two things have been satisfied. At some point, this case probably becomes moot. At this point, we've got these questions of the bar and that kind of thing. So what we have argued and what we believe to be correct is that Section 1319 ought to bar both kinds of relief. One of the reasons you have an interesting way that this came up is that was not a basis discussed in front of the district court. The district court raised that issue himself in a footnote, so we've briefed it here. And there is more argument for the reason that civil penalties should not be read so restrictively. We've also argued that the court should impose or should set forth an overall comparability standard for assessing whether a state procedure is similar to a federal procedure that's consistent with what the Clean Water Act says is the primary role of the states in enforcing and how the states choose to do this. EPA comes and evaluates the program and says, we think it comports with it, you have the necessary tools, you have the necessary procedures to enforce the law, and they give the states primacy for enforcement of the Clean Water Act, that ought to be honored. When a citizens group comes in and says, we don't like what the state did, we want you, federal judge, to make them do something different.
Thank you very much.
Your Honors, I'd like to begin first with the idea that it's unreasonable for Congress to have precluded only civil penalties under the diligent prosecution provision. Congress made a reasonable choice to set up this two-tiered preclusion scheme where under 1365B, all actions are precluded when a state or federal agency has initiated judicial action in a federal or state court. And to read the diligent prosecution provision in 1319 to also bar all actions, it eliminates the meaning in that statute when it states civil penalty actions are the ones that are precluded. And so it is not unreasonable for Congress to have done that, and courts should give the meaning to the statute, to the text that Congress has adopted. The legislative history surrounding the adoption of that amendment further supports this reading, that Congress fully intended that only civil penalty actions would be precluded under 1319.
I think we understand your position on that. Maybe you could direct your attention to the issues that were decided by the district court here and that you challenge.
Yes, Your Honor. In terms of commencement.
Right, that would be an issue.
Yes. I'd like to follow up on what Judge Heitens noted about 40 CFR 2213. And that scheme, 40 CFR Part 22, sets up the administrative penalty procedures for administrative penalty proceedings under Section 1319. And it specifically establishes that commencement of a proceeding can occur in those two ways, through the filing of a complaint with a hearing officer or through the issuance of a proposed consent agreement and final order. In either instance, 40 CFR 22.45 requires public notice of either of those instances. And so I think that clearly signifies that commencement of an action, commencement of a proceeding, is tied in with the triggering of public notice and participation protections. And in addition, Arabella Farm acknowledges that no public notice was given of the notice of alleged violation and claim that it's not required. We certainly disagree that it is not required, and for an action to preclude a citizen suit under 1319, the action has to commence before the filing of the citizen suit, and the only enforcement action that did anything to address the violations and to require any sort of compliance with the act occurred only after the filing of the citizen suit.
Counsel, did you argue in your brief, you may have, so we got a lot of papers and I may have missed it, but did you argue this CFR regulation in terms of commencement in your briefs?
I believe I did, Your Honor, and I'm certain that I argued it in my reply brief in reference to Arabella Farm's argument that an action commences with a notice of violation and that those are not public.
I'm not seeing it in the opening brief. Maybe it was in the reply, but it may be in there and I missed it. So that's okay. I can check.
And Arabella Farm argues that public notice is not required and points entirely to a series of public notice and participation measures that are triggered only after some final order, which simply did not exist here until after the filing of the suit.
But that's, you say final order, to be sure, an order, and that's on the agenda, and that's, the agenda's public, a description of the order's public, but it's not final until the DHEC votes on it, correct? I mean, there's an agreement and there's an order, but I don't think it's, maybe it is, maybe your argument is that it's final. Before DHEC votes on it, there is public notice that there's going to be a meeting about an enforcement order. Isn't that correct?
These consent agreements are placed on a agenda that the DHEC board considers in a effectively ministerial fashion. And
So
in either case, we contend that that is inadequate public notice, but moreover, that any public notice that occurs would have only occurred after the filing of this suit and cannot preclude the filing of this suit. And the notice of alleged violation indisputably did not have any public notice. Your Honors, we would ask the court to reverse the district court's decision, find that the plain language of the statute bars only claims for civil penalty actions, and further that the district court's finding that this entirely private, informal enforcement activity that occurred prior to the filing of the suit commenced an action that had preclusive effect, and respectfully ask the court's reversal of the court.
Okay, you are over time, so this is my time. I'm going to ask you one question. If we should decide for you right now, what would your role be then?
We would ask the court to remand so that we can move forward with our suit and prove the violations that occurred and obtain relief that's authorized by the citizen suit provision.
You would be acting in parallel with the state or against the state, or how do you see that?
We would be, well, we contend that the state's enforcement action doesn't really have much effect here and does not bar our suit in any way, but our role would be to establish the violations that Arabella Farm.
So it would be parallel with the state? You wouldn't be, yeah, okay, thank you. Thank you both for your arguments. We're sorry that we cannot come down and greet you. We hope the next time you're in the Fourth Circuit, we will be able to do that. Have a good day. And maybe you can send in the last group of folks. Can you go, Stuart?
I'm okay.
We're ready whenever you are, counsel.
Thank you, Your Honor. May it please the court, my name is Michael Jacks. I'm here on behalf of the appellant and plaintiff below, Redstone International, Inc. And this is a case about access to justice, and we're appealing a summary judgment order that granted summary judgment in favor of the defendant, the insurance market. And although Liberty Mutual is on the caption, they're not a party to this appeal. We have a separate order that was not appealed with them and a settlement with them.
Can you talk just a little louder?
Sure.
Yeah, great. I think it's me, not you.
So Redstone's a small construction company from southwestern Pennsylvania. And in 2014, they were awarded a large construction project in West.
Can I go back to something that you alluded to earlier, which is that earlier on there was another defendant who was still in the case at the time the order you're appealing from was entered. Do you agree that at the time summary judgment was granted between these two parties, there was no final appealable order? Because at that point, Liberty Mutual was still a defendant, right?
So what I did, Judge, is I believe the orders were 12 days apart. I believe it was October 20th of 2020 that the order for the insurance market was entered. And
right.
November 2nd, I guess maybe 13 days apart, that the order
order for Liberty Mutual was entered.
Right.
So I followed the 30-day notice of appeal window based on the 20th, just because I was trying to be sure. And essentially what happened with Liberty Mutual is they tendered a defense on the underlying action. This is, an insurance dispute, and they paid through trial. We actually finished trial in the underlying action. I think it was on October 17th of 2020.
Sure.
And they had a poison pill provision.
Right, but just as a procedural matter, if there are two defendants, the district court grants summary judgment to defendant 1, but has not yet resolved anything against defendant 2. Defendant 2 is still in the case. I think as a matter of just, maybe we can fix this problem, but at that point there is no final appealable order under 1291, right? When one of the defendants is still in the case.
Your Honor, I think if Liberty Mutual had not been granted final summary judgment, I believe both orders state that they are final and appealable next to the...
Well, a district court can't turn an order that's not final and appealable into an order that's final. Well, I mean, it can, but there's a procedure for that. It's called Rule 54B. But I mean, normally speaking, again, just there are two defendants to an action. District court grants summary judgment to defendant 1. During the time the action is still proceeding against defendant 2, there is no final appealable order, right?
I agree with you, and you would have to, assuming defendant 2 went through trial, you would then, if you wanted to appeal the summary judgment to the first defendant, you would do it after.
And I'm like, well, or you'd have to seek Rule 54B certification. You could also try that. So and my understanding is that in this case, the notice of appeal was filed during the window where defendant 1 had been granted summary judgment, but defendant 2 was still a defendant.
I don't believe that's correct, Your Honor.
I would love to be wrong about that, and I may be. I'll check.
I think I did it right at the 30-day window, so I think I filed the notice of appeal right about November 20th of 2020. So that would have been 18 days after summary judgment had been granted to Liberty Mutual. And that's all in the schedule and joint appendix. So to revert back, I do believe this is a final and appealable order. Certainly my client would be left without any recourse whatsoever without pursuing this appeal. And again, Redstone was awarded a $6.5 million construction contract. It's quite a detailed contract. It's the largest contract they'd ever had in company history. About that time, they had.
Wait, can I go back? I'm reviewing some notes I have. It appears to me that when you filed the notice of appeal, there were still 2 counterclaims that Liberty Mutual had pending. Is that correct?
No, because we settled with Liberty Mutual. So that way there's a settlement agreement.
That disposed of the claims and the counterclaims?
Correct.
That would be amazingly great if true. So I will check that. Thank you.
It is true. And again, they essentially had a clawback poison pill provision in the policy. So they tendered a defense in 2 separate actions, a state court action and a federal court action, that were 7 figures. I mean, it was an expensive case. There were 3 experts and 2 law firms involved in multiple cases. And the way their policy was written, if they won on the denial of coverage, they could get that money back. And Redstone simply didn't have it. So we negotiated a settlement where I agreed not to appeal the order as to them, and they agreed not to seek reimbursement of that money. So that's why they're not a party to this appeal. And so what this is about, and I think that it's really the heart of it, is how complex the dispute is between the insurance market, who was Redstone's insurance agent, and Redstone. And what Redstone did was get this complex contract with specific insurance provisions, and they're all cited in my brief. I'm not going to read them back to you, but they involve performance of the work coverage and contractual liability.
Mr. Jacks, could you help me out? Because what actual term of the contract do you allege was violated? Because I confess that having read the papers, I'm not entirely sure the language that was violated is X, as in terms of the contract issue.
In terms of the building contract required insurance.
Yep.
Redstone reached out, provided a copy of the entire contract.
But that's not a contract between, the insurance market is not a party to that contract. What provision of a contract with the insurance company do you allege was violated?
They said, Redstone said, we want to buy insurance for this contract. We have to have insurance under this contract. It's very specific what we have to have. And it was not provided. So I've got, well, the way this was pled was breach of contract and negligence in the alternative. What Judge Bailey and the district court ended up deciding was he looked at some West Virginia case law against attorneys and in malpractice claims, and he said, I'm going to deem your breach of contract claim to be a professional negligence claim, and I'm going to decide that you have to have an expert witness to unveil or unwrap the complexity of the dispute.
But didn't you agree with that? I mean, at least on appeal, the lumping of these things together as essentially a professional negligence claim? Because I can kind of, I think, perceive that if you have a breach of contract case, I'm not sure you do, but let's assume I can conceive of a situation where you'd have a contract with with an insurance agency, and you could say, here's my contract. It says 1, 2, 3. You didn't do 2. That's not an issue that you have to have an expert necessarily.
Yeah, I guess.
But just let me figure out. I want to hear your answer. But it seems to me that requires an objection to the lumping of the claims together. And I'm not sure that's before us. In fact, I don't think it is. So I think we're here assuming everything amounts to a professional negligence claim. Now, if I'm wrong about that, please let me know. But that's how I read the brief.
Judge, there are cases, and I don't remember the name, there is a Seventh Circuit case where they compare the two and they say essentially the breach would be the same, whether the breach is of negligence or the breach is in contract.
But that depends on what the breach is. That's to Judge Hyden's question. I mean, what's your breach? And if it ends up being, hey, you committed essentially professional negligence, I get it. Maybe it was proper to lump them together. Maybe it's not.
Let me give you an example. Say the contract said, you will get me an insurance policy whose policy limit is $2 million. And then it turns out that the insurance policy you got me has a policy limit of $2,000. It strikes me as intuitive that I don't need an expert to say that that is a violation of the agreement, because the agreement was policy limit of $2,000. I can read. I can see that it said $2 million and you got me $2,000. So that seems totally intuitive. You would not need an expert in that situation. But if it says, get me insurance that is appropriate to my needs, and I'm not saying that's exactly what it says, but imagine the contract says appropriate to my needs.
So that's a good analogy, Your Honor. And what happened here, it's not the limits that are in dispute. There's two specific things in the building contract: coverage for your work, defective work, and coverage for contractual liability. And the policy that was sold to my client was a generic CGL policy that excluded your work, that's one of the exclusions, and excluded any liability that my client assumed by contract. So just in the very language of the policy itself, we were done, right? So and that's one of the reasons we had this argument in district court level about whether West Virginia law applied or Pennsylvania law.
And look, I don't want to put your client in the bad spot because they found themselves in a difficult situation. But of course, at one point, your client was arguing that the insurance policy that they got actually covered this, right? It's not like it was self-evidently, your client literally sued someone claiming that the insurance policy they had actually did cover this thing.
Correct, and I did it, Your Honor. I'm the one who wrote the complaint. I've been the only attorney who worked on this, and a little bit of a stranger in a strange land down here as a solo practitioner.
You're doing fine.
I'm just saying in the 2 million, in the 2000 $2 million scenario, I presume you, or a lawyer, it doesn't need to be, in the situation where a client realizes, oh gosh, they were supposed to get me a 2 million policy, they only got me a 2,000 policy. I mean, you wouldn't even bring a lawsuit against the insurer in that situation. I mean, that would be Rule 11 sanctionable to bring it that way. So I guess, and again, you were doing the best you can for your client, but your own client took the position in litigation that this policy actually covered this.
Correct, Your Honor.
And is now arguing that it's so obvious that it didn't, you didn't need an insurance, that you didn't need an expert to say that it didn't.
And that's primarily because of the ultimate choice of law that Judge Bailey made. So in West Virginia, there is case law with contractors and especially with subcontractors. And we argued this. We had the original complaint and a motion to dismiss, amended complaint, and we argued it on a motion to dismiss the amended complaint, which we won. And if you have subcontractors, and there's several exceptions where these exclusions will not apply in West Virginia. So these exclusions as to your work will not apply, even if they're in the policy. Pennsylvania is different. So in Pennsylvania, the occurrence language and the damages language in normal insurance policies are much more strictly construed against construction companies. And to your point about the specificity of our allegations of breach here, whether it's in contract or negligence against the agent, I'm not saying that my contractor client went to an insurance company and just said, hey, get me some kind of policy for my jobs everywhere, right? They came with one specific contract with very specific requirements for insurance. And as so often happens with litigation, we end up dealing with the worst case scenario, right? So we get denied coverage, we lose the trial, there's a $3.3 million judgment, and this isn't in the record because it's happened after, but judgment enforcement collection proceedings are happening right now. So the sheriff of Washington County, Pennsylvania has levied my client's assets, their equipment. Because of that, their bank has put them in default. I mean, I'm not being dramatic when I say they're teetering on the brink of going out of business imminently, right? And this is their last gasp at trying to get some help. And I think, I know you've had some time in private practice. When you're trying to explain to somebody that drills holes and then puts steel and concrete in the holes, why they hired an insurance company to get them coverage and they have no coverage, it's very difficult for me to explain to them. They understand it. They would love to get in front of a jury and say, we just got absolutely hosed here, right? We paid for coverage, and it's important, this is all on the record too. So there was a policy renewal. The Liberty Mutual, this job started in 2014. There was a policy renewal in April of 15 when the Liberty Mutual policy was issued. And they went through the one broker first, and they said they went back to the insurance market. And they had this extensive correspondence where they said, we've had issues on this job. We've had earth movement. That's one of the things that was litigated because there was settlement that caused damage to what was being built at the job. And they said, we want exclusions removed. They did not get a copy of this policy, even though it was issued as effective of April 15th of 2015. They did not get a copy until June. They'd already had problems at the job that they got sued for before they got a copy of the policy. So the clients left, and this is more of the reasonable expectations argument that we had at the district court level with Liberty Mutual. That was one of my arguments, Your Honor, as to why there should have been coverage. My client expected coverage because they relied upon an insurance agent who received a copy of this contract, who had had correspondence about issues on this job, and told them twice, here's a certificate of insurance, you've got coverage, give it to you have to provide a certificate of insurance under these contracts. You don't just get to say, trust me, I have insurance, right? The people you're working for want these certificates. They're indemnified under the certificates as named insureds. So we've just had, it's just been one disaster after another.
Can I ask you, you were talking about the choice of law issue, and it sounded like you were talking about differences between West Virginia and Pennsylvania as they relate to coverage law.
Correct.
And maybe have missed something here. I thought we were talking about choice of law issues, not about coverage law, but about choice of law as in the context of whether expert testimony is required.
So they are different, and one of my issues with the appeal here, Judge, is that Judge Bailey entered this again on 12 days before the Liberty Mutual order, and in this one he doesn't say whether he's picking West Virginia or Pennsylvania law. He relies on cases against attorneys. I believe there's
Sure, but let me just finish my quote, because you may be answering it, but I just want to make sure I ask it in a way that gets the answer, because I thought that you argued, hey, Pennsylvania applies, but either way we win, because if it's not that complex, you don't have to have an expert. I didn't know that the issue was, okay, there's different coverage law issues. And so I just want to make sure we're looking at it the way we're supposed to.
So my position for the appeal, Judge, is that Pennsylvania law, it's a complexity analysis. So you can be required to have an expert in Pennsylvania depending on the complexity of the case. And my view here is that under Rule 56, the facts of that should have been analyzed and viewed in the light most favorable to us. So they should have been given every benefit of the doubt. And I really feel like when you look through this order, the opposite happened. And there's this listing of questions on pages 6 and 8 of this order that Judge Bailey then resolved 12 days later in the Liberty Mutual order.
Okay, but I'm not sure I understand your answer to my colleague's question. In other words, is it crucial to you, for this purposes of this issue, does it matter whether Pennsylvania law or, what was the other law? West Virginia law applied?
So it does, because there isn't anything prior to this case in West Virginia with a claim against an insurance broker there's no precedent for this in West Virginia. So I think because...
If we assume that West Virginia has granted, there's not an insurance brokerage case, but it seems like if you go to their general law on professional liability, that it's a pretty close situation, that it depends on the complexity. And if we were to analyze West Virginia as saying, look, in professional liability, lots of times you have to have an expert, but it's not absolute, and you got to see how complex it is. Isn't that pretty much, 6 one hand, half dozen another?
I suppose it could be, but because Judge Bailey picked expressly Pennsylvania law in the Liberty Mutual order, I don't think you can have...
But what we're trying to do is to figure out if that makes any difference. I thought you said Pennsylvania law allowed it, but I thought okay, go ahead, you talk.
So Judge, my understanding of it is, in Pennsylvania, there's no bright line requirement that you're absolutely required to have an expert for a case against an insurance broker, and there are Pennsylvania cases addressing claims.
Yes.
There is no West Virginia case addressing claims against an insurance broker. There's no precedent whatsoever.
Right.
And I don't see how you can have one state's law apply to one defendant in one order and then another state. And I'm just basing this upon reading his order, right? So Judge Bailey starts out his analysis in the order that's being appealed by discussing these West Virginia malpractice cases against attorneys. And I don't think that the complexity of suing an attorney and whether an attorney has made a mistake during the case is really comparable to this situation. I think this situation is much more simple. So that's the heart of it. I have a minute left here on the primary time, and I wanted to mention a couple other issues that I do have in this this appeal. And one of them is that there's a 2019 case, Trust Guard Insurance versus Collins from this court, and it was a car wreck case, but it was a declaratory judgment action filed by an insurer trying to get out of coverage on a car wreck case. And this court was very clear, and I think this is the important quote: decisions about indemnity should be postponed until underlying liability has been established. And I think that's what should have happened here too. I think that it's much easier for a court to look at a judgment and say, here's a policy, here's a judgment, is there coverage, than it is to say, we don't know what the judgment's going to be. So,
But I think your time's actually over, not decreasing, not
Right.
still left. So, but since you brought that up, I mean, you brought the case. I mean, yeah, and there wasn't a judgment at the time.
to get a defense tendered, and then I did file a motion. For
Look,
the state of-
I'm not criticizing. Look, I mean, practicing law's hard, and I appreciate your predicament. I'm not. Please don't take this as a criticism, but yeah, I mean, you initiated the case, and maybe there's even a standing issue about whether you had an injury at that time. But anyway, it seems odd to say I brought the case, and now district court, you need to put it off.
Because of Liberty Mutual, we had a partial settlement. They agreed to tender a defense. So once we got through the motions to dismiss, the defense was being tendered, and what I wanted to do was finish the underlying case.
Yeah, I understand.
And you're right. I didn't understand the light.
No worries.
We respectfully request that we just get a chance to present it to a jury. I think a jury could understand this, and I think that's the Seventh Amendment, right? Constitutional right to a jury. Just let us present the case to a jury, and they can decide whether there was anything that was wrong.
Thank you very much. Hear from your colleague.
May it please the court, my name is Anthony Sinceri. I'm an attorney with Burns White, and I practice at the Burns White Wheeling, West Virginia office. For purposes of the appeal, which is before the court for consideration this morning, I represent the appellee, the insurance market. Your Honors, for the reasons as set forth in the appellee's brief.
So, Mr. Sinceri, unfortunately, I have gone back and checked, and unfortunately, I think that the appellate jurisdiction issue I flagged with your colleague is, in fact, potentially a problem. So can I first ask you to see if you agree with me on the sequence of events here?
Certainly, Your Honor.
Okay, so it looks to me that on October 20th, which is docket entry 97, the district court grants summary judgment to your client, the insurance company, correct?
Correct, Your Honor.
12 days later, on November the 2nd, this is docket entry 98, the district court grants summary judgment to Liberty Mutual in part, but denies summary judgment to Liberty Mutual in other part. Is that your understanding?
That is correct, Your Honor.
So at that point, Liberty Mutual is still a party to the litigation with regard to the claims the district court has not yet resolved, right?
That is correct, Your Honor.
Okay. 11/20, Timmy files a notice, the insurance market files a notice of appeal. That's docket entry 99, correct?
That's my understanding, yes.
And then on January 21st, 2021, Liberty Mutual is dismissed from the case pursuant to an agreement between the plaintiff and them. Is that right?
That is my understanding, yes, Your Honor.
So my concern is that at the time the notice of appeal was filed in this case, there was no final judgment as to the whole case. Am I wrong about that somehow?
Based on that recitation of the procedural history of the case, Your Honor, I would agree with that point that you've made, yes.
Okay. I realize I'm springing on this you had oral argument, but unfortunately, being an appellate jurisdiction, we can't ignore appellate. So if you have any thoughts to that, but I won't put you on the spot because I realize you hadn't briefed it before this. Any thoughts on why that's not a problem?
To be frank, Your Honor, I didn't recognize it to be a problem. I didn't take notice of it, and was more concerned, to be honest with you, Your Honor, with
Totally understand.
that had been granted on our part and the clock ticking, so to speak, with regards to the appeal that was filed by the appellant.
Okay. I appreciate you helping me clarify that, at least from your perspective, I don't have the docket stuff wrong, because I realize I'm raising it. Thank you. So you can go on and proceed to what you were.
Thank you. Your Honors, for the reasons as set forth in the appellee's brief, we request that this honorable court affirm the order of October 20th of 2020, affirming the motion for summary judgment of the insurance market as to the appellant's claims for negligence, which are or have been asserted against the insurance market with regards to failure to procure insurance for the project, the Mobley project, as it's referenced in the briefing. And counsel for the appellant is correct. This was a complex matter. This was a construction endeavor that was subject to a 44-page contract with 16 discrete subparts there too. Of those 44 pages, 6 pages of that contract were dedicated to insurance requirements for this particular project. The appellant, as they've suggested, has presented their claims for failure to procure in the context of negligence, breach of contract, and unjust enrichment. But to your point, Justice Cordovon, the appellant's claims for negligence, or rather for breach of contract, are no different than their claims for.
Well, you know, why is, I mean, I have questions about whether that's even really before us. I mean, the district court found that. It looks like the parties kind of conceded that and then go down the road of whether or not you have to have an expert in this case or not. So I'm not sure it really is before us. But I think as to how we look at the issue, I mean, it seems odd to me that we would say or would need to say that, you know, any claim, you know, where professional negligence involved, you somehow collapse those. I mean, you know, we had an example earlier where we talked about that could be a breach of contract. Man, if all we had maybe was those September emails, maybe you could say this, I got a contract, I got 2 emails, I got a contract on that. You know, yeah, that strikes me that a breach of contract doesn't necessarily, just like a slip and fall, you go to the tort world. I mean, I used to do all that stuff. I mean, if I had a slip and fall case, rarely did you get an expert. If you got a private liability case, you got to get an expert. It kind of depends on what your case is and what you have to do to meet your burden of proof. And if a lay witness can do it, a lay witness do it. It's less about the nature of the cause of action than the substance. Isn't that right?
Correct, Your Honor. I wholly agree with that. And with regards to the substance of this action, we aren't dealing with automobile insurance coverage issues. We aren't dealing with homeowners policies, which your average layperson may have some familiarity and some exposure to in the real world in their year-to-year practice. Rather, we're dealing with commercial insurance in the form of commercial general liability insurance, completed operations coverage, and contractual liability insurance.
Let me ask another question. It seems to me the determination of the standard of when you need an expert is a pretty classic legal question. You know, what's the standard? The district court then here lists factors that it sees are sufficiently complex that require an expert. Is that part of the decision? I mean, we're here on summary judgment, so we review it de novo, I guess, but I guess that's what we would do. It just strikes me that kind of looking at the case and saying, all right, it's the sort of thing about whether a lay witness is competent or not, feels very much like a classic district court discretionary decision. Yeah, not the setting the rule, but I guess it's summary judgment. It just feels like the standard review here feels odd to me in that part of the decision.
And that's an excellent point, Your Honor. And
All your points are excellent.
both West Virginia and Pennsylvania courts recognize that there is no perhaps bright line rule with regards to the necessity of experts in professional negligence type cases. In fact, I believe that, as the Pennsylvania courts have recognized, it's not the nature of the transaction in and of itself, but it's the degree and skill that's required to execute that particular transaction. So simply because this matter involves insurance and the oversimplifying of this being just a matter of we requested this insurance, we didn't get this insurance. Well, I don't believe that that's necessarily the case, and the district court didn't necessarily believe that to be the case, because on page 7 of the order granting the insurance market's motion for summary judgment, the court recognizes that it appears that the appellant received the contractual liability insurance coverage as well as the completed operations coverage pursuant to the Mobley contract agreement. Additionally, on page 15 of the order of the district court granting Liberty Mutual's motion for summary judgment, the court recognizes that the appellant hasn't presented any evidence demonstrating that they didn't receive the insurance that they should have had or were required to have or could have had pursuant to that Mobley contract.
Can we take a step back and just, again, I don't know how this, but at a very high level generality, I think your colleague on the other side makes an interesting, like a fairly intuitive point, which is to say we're going to do a construction project. We absolutely need to get insurance against bad things that could happen during this process. I am not an expert. You sort of said that. I'm not an expert in getting insurance contracts, so I need to hire a professional to get me an insurance contract to cover against the bad thing. And they went to your client, and your client said, here's what you need. And then the bad thing happened, and then a judge holds that the contract, that the insurance that you provided them did not actually cover the very... Do you see what I'm saying? There's something about, I go to an expert to ensure that I go to an insurance expert to make sure that if the bad thing happens, I'll be protected. And now the bad thing has happened, and now a district court has held they are not protected. I don't know, why isn't that, I mean, maybe it's a simplistic, but there's a certain kind of logic that says the thing they hired you to do is make sure they're covered in the event the bad thing happens. The bad thing happens, they were not covered. Why do I need any more facts to know that you did not do the thing you were supposed to do for them?
Well, Your Honor, that's an excellent point. I think it's important to appreciate and recognize why the insurance doesn't provide insurance for the bad thing that happened. And as counsel for the appellant recognized, in this particular matter, the district court applied Pennsylvania law to the interpretation of the Liberty Mutual policy. And in its application of Pennsylvania law to the Liberty Mutual policy, the term occurrence, as recognized by...
Right, but presumably your client is an insurance expert, so your client should have anticipated, at least, I realize things judges do can be hard to predict until they do them, but I mean, I guess the fiction would be part of being an insurance supplier who sells insurance products to people is knowing how courts are likely to interpret those insurance policies. So I don't know how that helps you.
Well, because for that to be the case, the standard of care in this matter would have required my clients to be capable of conducting a choice of law analysis and recognize...
I imagine that a sophisticated insurance brokerage should probably be able to conduct a choice of law analysis. Otherwise, I'm terrified about whether they're actually getting me the right coverage.
And that's an excellent point as well. But again, that's something, a choice of law analysis is something that the average layperson is most likely incapable of understanding.
No, I said, no, there's all this talk about negligence versus strict liability. I mean, it depends on what the contractual duty. I agree with you as a negligence matter, but as a contract matter, I mean, most contract liability is strict liability, right? If I contract to sell you my car, and on the day in question I do not produce my car, and I was like, I'm really sorry I don't have the car, but I have a really good explanation for why I tried as hard as I could to have the car here today, but I couldn't. In contract, the answer is, sucks to be you. You contracted to supply a car, you did not supply a car. The fact that you tried really hard or you have a really good reason is not a defense to a breach of contract action, right? And part of the reason for that is because contract actions, like we're not sending you to jail, we're not imposing punitive damages, right? Contracts are just either do the thing you said you would or pay. And so at some level, I think what your friend on the other side is, you said that if something bad happened, you would make sure that someone other than us has to pay for it. And one way you could do it was by procuring an insurance policy. But the other is that if you don't, you have to pay. I guess, again, that's a very simplistic way, but I want to get, it just seems to me very strange that I go to an insurance company to say, make sure I'm protected if the bad thing happens. And then the insurance company doesn't make sure that I'm protected if the bad thing happens, and then further says they don't have to pay me because they failed to make sure the bad thing didn't happen.
And that's an excellent point, and I certainly see the points. But
So why is it wrong?
Well, because again, I think we're talking about the necessity of an expert in the context of procuring insurance as to the appellant's claim.
But so Judge Quattlebaum has said, and that's my sense too, which is the question of whether you need an expert depends on how hard the underlying question is. And if I conceptualize the underlying question as, you promised to get me insurance that would cover this, you did not do that. I mean, if that's how you conceptualize the promise, that doesn't strike me as a difficult question. That strikes me as a really easy question. I don't know why you need an expert to say that.
Because it's the process of undertaking that exercise of procuring insurance, appreciating what the insurance needs are of the respective client.
So let me give you imagine that the contract, this is weird because I'm not really even sure what the written contract is, but imagine that your contract with them said, we warrant that the insurance we get you will cover if there's a cave-in. And then the insurance that you get does not cover them when there's a cave-in. Would you be liable then? For breach of contract, if the contract says we warrant that the policy we provided you will cover this?
I would concede that in that particular set of circumstances, those set of facts, that hypothetical, yes, because there is a written agreement. There's a written agreement that expressly identifies the contractual terms. That is not what we have here. There was no written agreement by and between the insurance market and the appellant with regards to securing a particular type of insurance coverage or...
Why not? I mean, and you may be right. I mean, it's a weird thing. You got 2 emails in September. Yeah, here's my contract, get me insurance. Says something like, I got it, or something like that. Not a lot. And I guess if that's a contract, one way to look at that is you said you get insurance. I need insurance for what this contract says. You would say, I got it. You've provided it. Then, if the story stopped there, maybe that's one thing. Then we got a bunch of emails about 2 or 3 months later where there's just back and forth about different things. And, that may be the weakness in the plaintiff's argument, that if it was all right in September, maybe we could have a simple breach of contract case like Judge Hyten's saying. But, back in February or whenever it is that they start having this back and forth, it seems to suggest maybe it wasn't that simple. And there was no one who said, look, you said I have insurance. There seems to be some recognition once we get to there that maybe it's a little bit more complex. And maybe that's a reason to lump this stuff together. But, it is, normally, and maybe this would go to whether you fulfilled your duties. Normally instead of sending that email in September, it says, I got it, say, hey, let's be careful here. It's not that easy. Warn them a little bit that you may not get this sort of coverage. It may be expensive. And maybe that's what all goes into a negligence sort of claim. But, anyway, it's an odd set of facts. And the September emails, have some appeal to, I think, Redstone's argument. It gets more complicated maybe when it goes later.
I agree, Your Honor. I agree. And if I'm recalling correctly, the certificates of insurance that were provided were certificates of insurance for the subject Liberty Mutual policy, which the district court recognized contained within those Liberty Mutual policy, or that policy, was exactly the contractual liability insurance coverage, as well as the completed operations coverage.
Do you have a position on, and I'm sorry to interrupt you after asking a long-winded question, that's pretty rude, but do you have a position on whether there was a contract and what it was?
It's our position that there was no contract, that the plaintiff's claims for contractual liability or breach of contract are nothing more than a recitation or regurgitation of their claims for professional negligence. Your Honors, I think it's compelling in reviewing the district court's order to recognize that the district court not only looked to Pennsylvania law, which the appellant is suggesting the court, or to the court, should have been applied by the district court in rendering an opinion or ruling on the insurance market's motion for summary judgment. It also looked to West Virginia case authority. It also looked to other states' case authority on the particular issue of the necessity of an expert. However, one of the cases that the district court recognizes in the form of a Pennsylvania case is 151 First Associates versus Hofstetler, which is a case involving failure to procure insurance as to a negligence claim being asserted for the city, and the requirement of expert testimony being required in that particular matter. I bring that case up because at page 23 of the appellant's brief, the appellant suggests to the court that had the insurance market simply provided modifications to the endorsements to the CGL policy or provided builder's risk insurance coverage, there could have been or should have been insurance coverage available for the indemnity that the appellant seeks for the underlying West Virginia State Court proceedings. The Pennsylvania Court in 151 First Associates specifically recognized that that particular type of insurance requires expert testimony to demonstrate that there was a breach in the standard of care in procuring that particular type of coverage. So the very type of insurance that the appellant is suggesting could have been procured, which, to be honest with you, that's the first that we've heard of that particular type of insurance. Number one, being available to even provide the coverage for the losses that they seek indemnity for the underlying West Virginia State Court claim requires expert testimony, as recognized by the very court that the appellant is suggesting or requesting this court apply their substantive law of Pennsylvania. With regards to the appellant's assertion that there should have been a stay or that it was premature for the district court to rule on the insurance market's motion for summary judgment, based on there having been no determination of liability in the underlying state court proceedings, such was unnecessary. There wasn't any factual predicate or legal issue that was necessary or germane for the district court to have before them, to have had determined for purposes of the district court determining and looking at the four corners of the plaintiff's complaint, recognizing what the nature of the issues are with regards to the negligence claim asserted by the plaintiff or the appellant as to the insurance market, and whether expert testimony would be required for purposes of the appellant satisfying the prima facie elements for purposes of a negligence claim. So as far as that aspect of the appellant's suggestion that the ruling by the court, the district court, being premature based on there having been no determinable liability in the underlying aspect of the state court proceedings which the appellant was a party, such is inapplicable here.
You don't have to use all your time.
I'm sorry, Your Honor.
I say you don't have to use all your time. If you're done, you can sit down.
I appreciate that, Your Honor. Just very quickly, the last form of relief requested by the appellant in their brief is being permitted, if the court finds that expert testimony is necessary, to be permitted to designate an expert at this particular point in time. Well, up to this point in time, the plaintiff or the appellant has vehemently denied that an expert is required. And they certainly haven't showed substantial justification or that the same would be harmless in this particular posture of the case. So with that said, Your Honors, I appreciate your time. We just respect the request for this court to affirm the district court order granting summary judgment for the insurance market.
Thank you very much.
I'm going to try to address the points. There are a lot of interesting points that you all just discussed. On the jurisdiction issue, Your Honor, I'm thinking about this like going to court, and I never want to be late for a hearing, right? So if anything was premature, a little bit, if I wasn't supposed to file that notice of appeal within 30 days, I'd rather be early than late. I feel like if I'd have waited until February 2021 and filed that notice, I would have been in big trouble, right? So I think
These things are very complicated.
if there was a concern, I believe it was mooted by the rest of the case properly resolving without any substantive order by the district court. Again, there were brief settlement negotiations with Liberty Mutual. We did a settlement agreement, and they were dismissed. When you were discussing the complexity or what Timmy could do, so the insurance market is a big company. So they have a big office in Maryland. They have a big office in Delaware. I think they're licensed to provide insurance in 15 or 20 different states. It's what they advertise on their website. Mr. Waters, who was the agent in this case, was licensed to provide insurance in both West Virginia and Pennsylvania. So we certainly think they should have been able to look at this and say, either you have this or you don't. And to your point, Judge Quattlebaum, about the timing of September. So in September, there was a different policy from a company called Kinsale, which was subject to arbitration, not party to this case. They were in the middle of that policy. So Redstone either had coverage under that policy, or they could have gone out and purchased something else. So the insurance market had the opportunity to review the existing policy and say, either we're going to issue a certificate of insurance or we're going to tell you, please go buy something. And that's one of the key factual things that there is no written record of here. The insurance market never warned Redstone you don't have coverage. It never happened, right? And Mr. Waters testified in deposition, I warned him, but it was oral. There's no written record of this. There's no reaction to it. Clearly, if the company's in the middle of a $6.5 million job with issues and they're dealing with the renewal period and they need a new policy to cover potential issues on this job, tell me, please tell me I don't have insurance, right? So it's not just, could you buy it? If he couldn't find insurance for this, and another important point here on the front page of this contract, the building contract, this is a form contract. This is the American Society of Professional Engineers. There's several other societies of engineers. They do these, they copyright them, they provide them to parties. You can edit them a little bit, but they're done so that contractors and engineers and architects do not have to go out and write these things from scratch. These are normal. This is not some off-the-cuff, back of a napkin insurance provision. These things are used all over the country. There is insurance you can buy for these. And I don't understand why that's even in contention. The other parties in this case had very similar contracts and they had insurance for this. Okay, so on the necessity of the expert issue, when you look at the questions in the October 20th order that we're appealing, that Judge Bailey lists on page 6, 7, and 8, he answers those questions in the Liberty Mutual order on November 2nd. And I think that's appropriate because it's a declaratory judgment action, and he's interpreting a contract under the law. That's what judges do. Experts aren't allowed to do that. Experts don't offer ultimate issue opinions. You don't hire an expert who comes in and says, that's negligence. They can say, here's what they should have done. Here's maybe they can opine on standard of care. They don't get to just say, this is the law. The judge does that.
Can I ask you, did your client ever ask the district court for the opportunity to designate an expert?
No, because discovery closed, and actually we both, so.
But like after the district court ruled against you saying that it concluded you need an expert, did you ask for leave to be permitted to do that?
No, because he designated this as a final order and I appealed it, Judge. I mean, it ended the case. So it happened after the close of discovery, and we actually both opposed, we asked for an extension to discovery to do more discovery. Liberty Mutual opposed it. The judge sided with them. That was earlier in the case. And on the contract issue, Judge, I'm not presenting or arguing that there's a specific risk of contract. This is a contract from course of conduct. And this is not simple negligence where you alluded to slip and falls. I've done a few of those myself. There's never going to be a contract in a slip and fall, right? It's an accident. You're either in a parking lot or in a store, something happens, right? So what happened here, again, one specific job, we need coverage for this job. We're never told they didn't have coverage under two different policies. The judge decides they don't have coverage. $3.3 million judgment they can't pay, right? That's the straight line, ABC. I think it should be, and I apologize here, I see I'm over.
You are over time.
But to me, that's something that should not be thrown out of court as a matter of law based on complexity. And thank you, Your Honor.
Thank you very much, both of you, for your arguments. You usually come down and shake hands with the lawyers, but we can't do that right now. But perhaps the next time you're in the Fourth Circuit, we will be able to. Appreciate your arguments. Excuse me. I'll ask the clerk to adjourn court.
This honorable court stands adjourned. Sine die. God save the United States.